May I please, Lord? My Lord, item number 13. Charge sheet submitted, my Lord, on last occasion report came, my Lord, charge sheet. 13.
13 file.
1-3.
Can you tell us the CS number?
My Lord.
Lordship, after some time, Lordship, the file is not available with me, Lordship. I have to inquire. After some time.
Anyway, otherwise we are sufficient that that
My
has
Lord.
already been filed.
My Lord.
So if we'll get to go through the record, the people see the record, then we'll pass the
My
order.
Lord.
But your petitioner was an interim or no?
No.
He was not.
I will approach the trial court, my Lord.
Yes, definitely.
That is the appropriate.
13. It will,
13, 1-3. Highly obliged.
we will
It could be.
CS number. Otherwise, order will be there. Will be distributed.
May I please, Lord? With the concern of the petitioner side, I beg to mention item number 22. It will carry adjourn for the day, Lordship.
C22 is of 2011.
Yes, Lordship. There's some difficulty. I am appearing for the state of Mizoram, Lordship. Lordship, may kindly fix it on first week of June, Lordship.
Only for
So you are for the
State of Mizoram,
Mizoram.
Lordship. Yeah.
Okay. State of Mizoram. State for after 1 week it will be. After 1 week.
Yes.
Then it will be by the ministry.
Highly obliged.
May I please, Your Lordship, I beg to mention item number 24 of today's list. Ma'am, my Lordship, matter may be passed over for the day.
Why?
Advocate Rajiv Agnihotri from Delhi will argue the matter, but he could not come due to personal difficulties.
Have you informed the other side? Because
Yes,
there are lots
yes, my
of-
Lord.
Huh?
Yes, ma'am.
Have you informed? Do you have any convenient date?
Next Friday.
Next Friday is not.
Any Friday would do.
Any Friday.
Friday is possible.
Any Friday. 13/6.
13th.
One.
All right.
May I please, my Lord? My Lord, as regards to the victim in amicus security, my Lord, in item number 4, my Lord. She has a medical emergency, my Lord. She is asked to mention the matter.
MS PDAS.
PDAS, my Lord. On request of PDAS, my Lord. I am appearing on behalf of R. Bora. There is a petitioner, my Lord.
You are Mr.
PDAS.
PDAS, appearing on behalf of Hardware. Subject that MS PDAS. The Michael appointed on behalf of the it's not as their can complete accordingly after 2 weeks.
My Lord, can it be fixed on Friday, my Lord? Because there is some urgency. My Lord,
Urgency was there, you have
I'm challenging the quashing of entire proceedings, my Lord. My Lord, I'm challenging the quashing of entire proceedings, my Lord. So,
yes, what to do? You are
will you proceed, my Lord, in the trial court?
You prayed for adjournment.
No, I'm not praying for adjournment. I'm praying on behalf of the informer amicus security, my Lord. Can it be on Friday, my Lord?
Next Friday? No,
This
not
Friday, my
possible. Next Friday. It will be
No,
late.
it will be, my Lord, too late, my Lord.
14, Friday 14 June
Friday will be 14.
14.
Will be 14/6.
My Lord, that will be, my Lord, can be in the month of May, my Lord.
May?
Yes,
No, not possible. Month of May is not possible. Can it be? No, I think. Month of May is not possible. 14/6 or
7, you want Friday?
Any day, that is not an issue, my Lord.
Or
11/6,
11/6.
Tuesday, hearing day. We are.
Obliged, my lord.
Lordship, regarding item number 13, Lordship, I have found the CS number, Lordship.
What is this?
CS number is, Lordship, 118
118.
oblique 2024, dated 31/3/2024.
Okay. Okay. No it.
May it please your lordship. My lord, here the petitioner is around now 80 years old. My lord, advocate. The case of the petitioner was that he was a penal advocate of a bank. Some documents were furnished to him for giving his legal opinion about the documents. And on perusal of the documents, he has given a opinion to the bank. My lord, loan was sanctioned after the valuer and others appeared before they have gone to the land and they have seen the land, they have valued the land, and the manager has sanctioned loan. After the loan was given, my lord, some portion of the land was sold by the person who took the loan. That person took the loan. Then, my lord, on basis of some documents, and Namzari and others, he has given this opinion. Now, my lord, because there is a cheating, the account become NPA. Then he was not giving back the loan amount. So ultimately, my lord, charge sheet has been filed against the advocate. His only thing is that he has given a legal opinion. If your lordship may look into the record has come, page 6 of the record, my lord. I will place your lordship with the affair, my lord. Your lordship may look into the affair. The allegation is this.
So, Arguti case here now.
My lord, because it's not a motion, my lord.
It
The record has also come, my lord.
Charge-sheeted case, my lord.
Against the charge sheet I have come, my lord.
Charge-sheeted case, my lord.
I have against the charge sheet, my lord.
We are on number one. So it is in motion stage, in fact.
No, my lord, previously motion was there.
Then
There was an order
wrongly
passed.
maybe.
Justice Ajit Bhattakur has
Yes,
passed.
I have seen the order. Yes, that's Arguti.
My lord, I have to examine the since it has come in the motion column, my lord. I could not go to the LCL. But let it come up for admission, my lord, in
My lord,
that case.
can I
my lord.
pay with my due consent from my lord? He is a 80 years old man, my lord. My lord,
He may be 80 years old, but he has to pay.
my lord, only thing is this, my lord, at this moment for few days, if this proceeding can be stayed, my lord, for few days, my lord, because
We
the,
hear the matter in the admission stage.
my lord, I was ready, my lord, today I was ready.
Let it come up tomorrow, my lord.
Tomorrow I had some other cases, my lord.
Tomorrow, yes, tomorrow.
But stay, my lord.
Stage cannot be because in the earlier order also there was a prayer for filing a representative petition for
Yeah, my lord, that representation we have filed, my lord.
representation will file. So stay will not be there.
Next week, any day.
My lord, next week it will be. Can it be on 6th, my lord?
6th of June.
June. Oh, 6th of June. Oh, my lord. Not 6th, my lord. Then it will be 27 तो हवे ही ना 28 हो. My lord, only thing, my lord, only one prayer. On 30th there is a day in the trial court. Only that much your lordship may give that I can file an application for adjournment on that day. On 30th. That much, my lord, liberty may be given to me that on 30th I can file an application for adjournment.
Now see, application for adjournment will come later, but because the Justice Bhattakur has already given you one,
205, my lord, that day.
you can apply for representative.
No, I have filed a representation.
Then it's
but,
okay.
but that day, my lord, the court has asked us to appear before the trial court has asked us to appear before the court. Only thing that, my lord, only if an application for adjournment may be allowed, next day we will do my hearing, my lord.
Kind of order. It will not.
Because my other courts are giving a liberty to
30th.
30th, my lord.
Okay. Can it be on 28, 29? 29. We are listing it 29.
29th.
List on 29 for any admission for
My lord.
29. What to do here? Why these are which are around 6-7 meters there? What?
My lord, case diary is not there, my lord. My lord, we sent WD message on 5 occasions. I have not received the case diary. Perhaps he is on interim, my lord.
He's an interim. But the DD is not received.
Not received. As many as 5 WD messages have been sent.
Then it appears on paper. However, it is subject Mr. He does return it that in spite of sending 4 or 5 numbers of signal to the IO for setting his diary, it has not hit his diary, the comma, the IO page, then you data bridge method that I to what is the case that on not voting it for he will be served paper. It's according given
5th of June, my lord.
it's not I till the interim period.
Kindly for the time being, Miss KDB is on left lordship.
Huh?
Miss KDB, MRS KDB is appear before this, in this case lordship. He is on left lordship court now. Kindly for the time being. Kindly.
Lordship, kindly matter may be taken up at 2 Lordship. My senior is not available right now.
Two hearing may start, then it may not reach. Because today is the hearing day, we are speaking.
There are other connected matters also, my lord. Item number 11, 14, 15, and
Item number 11,
11, 14, 15, and 16.
16. All are connected.
16 all are, my lord, not same case there.
Oh.
So let all the matters be taken up at 2 p.m. If it is not
I
inconvenient.
don't know.
Some of them are on, my lord, interim bail, I think.
Item 15 to the city and
15? 15 to same number. 15 to CDI se tu. 15 है ना गौरीपुर PS 99 ना कौन था ना 15
So 11, 14, 15 and
11.
16 are connected.
15 मतलब same case there मतलब
12 is different one.
मतलब
12 is different case.
12 is different.
Lordship, I am on interim Lordship. 11.
Whatever, 2 p.m. it will be on 2 p.m. CD is here.
Or let it be for time being, we'll see one item already.
All are 2 p.m.
2 p.m. or for the time being, it's senior.
Before 2 p.m. Lordship, before break Lordship, anytime.
How can I say before break and all? Well, calling the case at present. So other matters can be heard otherwise.
Yes, yes.
Yes, okay. Why are you waiting for?
Yes, yes.
Okay. You are ready?
Maybe taken up together, madam.
In which item you are?
14. Maybe taken at 2 p.m. madam.
And you are on item number?
16.
16. 16 can be heard.
Lordship, we can take together here, Lordship. At 2 p.m.
Together. I don't know if it reached 12 to 2 days, otherwise. Okay.
12, my lord. I'm sorry, my lord. Mr. K.K. Parasar has examined that case there, my lord. A little bit time, my lord. He has item number 1 in adult court, my lord. As soon as he comes, my lord. 12. Come on, Roa. Come on, Roa. Admit. Item 2.
You are for the respondent?
Respondent number 1. I have filed my reply also.
They filed your reply also.
In this matter, Your Lordship, they have challenged order dated 24/2/2022, by which Your Lordship, an application filed by the respondent number 1, maintenance award from 1,500 to enhance to rupees 7,000.
That is the case.
I have the humble submission, Your Lordship. Petitioner, Your Lordship, is having monthly income more than 80,000. And while passing the order, Your Lordship, family court has put reason, Your Lordship, why the amount has been answered. May I read that?
No, it's okay. Other side is absent. Petitioner side is not available. In that case, also Mr. H.R. Chaudhary is there.
Yes, sir.
In the time, in other case, he paid time. By keeping it on for time being, let us see.
At 2 p.m.
I cannot say 2 p.m. All will be fixed at 2 p.m. How can I say?
May I plead, Your Lordship? Your Lordship, petition is against the order dated 26/9/23, passed by the Special Judge Jorak, whereby rejecting the petition number 1066/2023 filed by under section 311 CRPC, filed on 5/7/23 for recalling the PW1 victim and PW9 officer in charge, so to cross re-examine them, Your Lordship. Your Lordship,
That was rejected.
rejected. My petition was rejected. That
Where is your impugn order?
Page number 16 is the order, Your Lordship. The order that was passed by the.
It's a POXO matter.
Lordship. Your Lordship, the initially FIR, Your Lordship, page note 25 is the FIR, Your Lordship. Kindly, page note 25. I copy, Your Lordship. May I read, Your Lordship? With due respect, I beg to state that I had filed a notice to the police station before my about my daughter who has been missing since 2 p.m. yesterday. In this regard, the OC and other members of the police station recovered my daughter after a lot of time and handed over to our family. So we take her to our house and she told to the police that she had left the house alone. At about 5 p.m., she informed one neighbor sister-in-law that yesterday night, so mobile repairing shop, the 3 boys had done bedrock.
My lord, sorry to interrupt. He just now he communicated to me. He wants times more
file
profiling
objection on behalf of respondent number 2, informant father of the victim. On
File objection.
Lordship. The victim was aged about 16 years, Lordship. At 2 p.m. altogether
In this
the
case,
accused
from
person.
HCR, it appears already 10 PWs have been examined. 10 PWs,
on
on
the
the fag end of the middle trial.
On the verge of the judgment, Your Lordship. It is already too late, Your Lordship. It is 311 petition. And we want to examine only the victim and the IO who has taken statement of the victim before registering this FIR, Your Lordship. That we somehow overlook and we overlook and could not cross-examine the IO on that matter, on the statement recorded by that IO, with recorded statement of victim before registering this FIR. That we overlooked and that we wanted. Very simple prayer, Your Lordship. And it is only on the verge of the judgment, Your Lordship. If it is
On behalf of respondent number 2, Lordship, SK Sarkar.
For some uptime. Confident prayer made by the data account. For the number. How many weeks do you want?
2 weeks, Lordship. 2 weeks.
2 weeks, but at the time of probably case
too long, yes.
under the progress.
otherwise, it will no use, Your Lordship.
1 week.
1 week later.
1 week.
Do you want any fixed date?
Date.
Any fixed date? 3/6 we have to see. By
Lordship.
3/6 you submit your written
Lordship.
objection. So
Lordship.
that it and after the council by the so 10 IO will be examined at the later part, I think. He
Yes.
has already, I was, he's
I
already been
examined you
examined.
already. Examined. Thereafter, we came to know that that part was missed, your lord.
See, this is the case of POXO. So
Lordship.
let us see. Okay, please.
Well, obviously.
Obliged.
Item 5.
This is regarding that Zimma Malad. Malad wants to that confirmation of the order. Already I was stated that he has no objection. Malad vehicle is not required for further investigation. And in the impugn order, by the lower court, that is mentioned that vehicle agreement is subject to approval by the competent authority.
Yes.
Now I have received Malad today morning that.
Lordship, kindly pass out a matter for a time being, Lordship. Engage counsel, cab or wise.
Now I have stated that Malad, though he informed to the competent authority at Kolkata, but their confirmation not yet received. It is subject to confirmation, but no any such order has been received by the IO, Malad. It is clarified, Malad.
And the earlier report is not required.
Not
for the day?
record on 17.5, maybe in the file.
No, you have not.
Malad,
In your file.
Malad, I'll take a print out from the.
Watch it. No. This one we have. No,
Yes.
other
report, Malad, I have taken on print out from the. I am just. It is 17.5 years.
It was 617.
I am just given one print out.
Oh, sorry. It is.
Earlier also is stated that not required. Even more
Let him let
Lordship,
inform
kindly pass out for time being, Lordship.
the space.
timing. Usually not required for current more. Okay. Then the council may come. On the council.
Yes, I'm okay. Last occasion.
Oh, he.
Yes,
I don't know whether that MS is already joined or not.
Yes.
I don't have any instruction, but yes, already all rituals have been over. But whether she joined. Mr. Das, do you have any information whether Miss Saikya has joined or not? Her father expired.
Last
Acha.
occasion.
Hello, she's supposed to join this week, but I don't think she's yet joined, Michael.
Most probably. Let the matter be discussed after.
Yes. After 2 weeks.
After 2. Okay, done. As hard to check. Let that be it. By yeah. But that but there's no hope. Better be.
Only a date will fix because he is inside. A date will fix.
One thing.
Lordship, kindly pass on about time being lost. Okay, boy is on election on the court. What a time being lost.
You cannot be in a position to stay.
Otherwise, this is a matter which could be disposed of today itself.
Today. Till back.
Okay.
Now see, all the timing matters, but I cannot say whether it will reach or not.
482 application for quashing of a criminal proceeding.
Yes.
Petitioner accused and informant jointly filed this petition.
It was a joint petition.
Joint petition for quashing the Gulfport Police Station case number 75 public 2020.
Now 3 petitioners are here. Who is
Plus
who? 1 and 2.
1 and 2, let's say. 1 is informant.
1 is informant.
Let's say 2 and 3 accused.
Was there any victim?
Let's see.
Was there any other victim?
No, let's see.
Only Vinay Tosa is the only victim.
Let's see.
Plus he is the informant also.
Let's see.
Where is the FIR?
FIR, let's see, page
18, you know?
Page 18. Short page. All are lost business partner, monetary dispute. One small quarrel was held. They settled by agreement.
Agreement.
Agreement. Annexure 4, page 28.
Where is the original FIR?
Original FIR, let's say, page
Not the translator, the vernacular one.
Vernacular is page 22.
22.
Yes, that's anything.
Is there compromise?
What was the stage of the case? That was already filed.
Charge file appearance.
It was an appearance.
Appearance for NBW has been issued. Page 33, you know?
Acha.
Against petition number 2. Both.
Against both sides.
Page 13, let's say, that is larger bench Supreme Court says that High Court can quash 307 also quashing petition lawsuit after submitting charge sheet.
Otherwise, injury is simple, you know, page 27.
Mr. K. Borwa?
L. Gogoi.
Oh, sorry, L. Third Mr. L. Gogoi. Mr. Gogoi did not copy that the petitioner number one, the petitioner number one informed that the victim of this case and the other petitioners are the the fact that there was somebody but and give up entered at that time but subsequent it came to they have certificate person they have certificate and person that also entered zero of my on and after or they are already and some fun if Mr. Mr. Booker done order guide order at court in case of the Dinare and the Pera said with an appointment that if the case of compromise authority it can be court in 307 cost if the party has party submitted that has been there is no chance of conflict proceeding around conflict is that did not get by the expert and from medical it was simple and for but that has been part of the several it that the batteries if the proceeding that enforced applying exercising power for okay, your business.
Obliged. Today the date fixed for disposal of the order, my lord, the matter pertain to my lord.
Lordship, my son is left in another court, my lord. That's what I'm looking for the timing, lord.
Timing, lordship. We have some urgency and act matter. 12 lakh rupees now hanging on account of only this limitation petty. Just
no. He is coming.
Yes, after some time. No, after some time, madam.
Yes, ma'am.
Please, Your Lordship. And this will be the bail petition, my lord, it is for my lord.
Yes.
My lord. FIR is a page number, my lord, 18, my lord.
18.
The FIR, my lord, and the vernacular one is at page number 21, my lord. May I read the vernacular one, my lord? মহাশয় বিনীতভাৱে আপোনাক জনাওঁ যে মোৰ ছোৱালী মিছ আবিয়া খাতুনক তেওঁৰ স্বামী ৰুস্তম আলী আৰু নিম্ন নাম উল্লেখিত পদকীয়াগণে লগ লাগি গত ইংৰাজী 11/12/2023 তাৰিখে নিশা প্ৰায় 12:30 মান বজাত তাত কেৰাচিন ঢালি জুই জ্বলাই দিয়ে। লগে লগে জখমীক মঙলদৈ চিভিল হস্পিটেলত ভৰ্তি কৰা হয়, যদিও জখম গুৰুতৰ হোৱা বাবে তেওঁক GMCHলৈ উন্নত চিকিৎসাৰ বাবে প্ৰেৰণ কৰে আৰু সেই মৰ্মে সেইদিনা জখমীক GMCHত ভৰ্তি কৰা হয়। যদিও পিছদিনা অৰ্থাৎ 12/12/2023 তাৰিখে GMCHত তাইৰ মৃত্যু হয়। ইয়াৰ পূৰ্বেও পদকীয়াগণে জখমীক যৌতুক দাবী কৰি বহু কেইদিন শাৰীৰিক আৰু মানসিক অত্যাচাৰ কৰিছিল। বৰ্তমানো যৌতুকখিনি জনিত কাৰণতে তাইক হত্যা কৰিলে। Thereafter, my lord, all the FIR named accused filed in anticipatory bail petitions, and that anticipatory bail petition was decided by your lordship, my lord. And that anticipatory bail petition, your lordship has granted bail only to one person, my lord, Malik, accused number 4, my lord. On that bail petition, when your lordship rejected the bail prayer, categorically stated that due to the preliminary stage of the investigation, bail application was rejected, my lord. So now, my lord, whatever in the CD, my lord, that is one thing, and it is categorically stated in the bail in the order, my lord, which is at relevant portion is at page number 28. There is no indication in the FIR when there was any dowry-related torture has been made. No specific that has been mentioned. Even the marriage was solemnized 5 years ago, my lord, and there is a child also. But during this period, if there is any dowry-related issues, my lord, then obviously there will be any case filed against the husband or his family members, or there is any local male, my lord, wherein this kind of dispute were solved. But there is nothing such happened, my lord. And that apart, the FIR was lost after, my lord, as per the FIR, incident was happened in 11/12, and victim died on next day. But the FIR was lost on 14. So we have doubted under the influence of someone, my lord, this FIR was lost. Because during this period, all the formalities, rituals has been done jointly, my lord. And that apart, my lord, the FIR named accused themselves, my lord, took the victim to the hospitals, my lord. And whether there is any that statement or what the doctor has been said, this is not disclosed in the earlier occasions, my lord. Whether there is anything like that, and whether any independent witnesses stated anything against the present petitioners, because obviously, my lord, the relative of the victims and the informant, obviously they will support their case, my lord. But whether any independent witnesses surrounding the areas stated anything against them, that there is any kind of dowry-related tortures, my lord, that is the important to be look out, my lord. So at this instance, my lord, may look into the CD particular is in CD, my lord. Thereafter, I reserve my argument, my lord.
Well, as per the postmortem report, death was due to shock as a result of antemortal dermoepithelial burn injuries comprising of approximately 76% of total body surface area. Now, one witness, informant was informant in the FIR stated that informed by a girl of the village and telephonically. Then we come to know that witness Hanufa Khatun, he stated that আবিয়া খাতুন মোৰ সৰু ভনী হয়, মোৰ সৰু ভনী স্বামী ৰুস্তম আলী ঘৰত নিচেই ওচৰতে মোৰ ঘৰ। যোৱা 11/12/23 তাৰিখে সন্ধিয়া 7 মান বজাত মোৰ ভনী আবিয়া খাতুনৰ শাহুৰী মালিকা খাতুনে মোৰ ঘৰত আহি মোৰ ভনীজনীক গালি গালাজ কৰি থাকে। মই মালিকা খাতুনক কিয় গালি গালাজ কৰি আছে তেতিয়া মালিকে কয় যে মোৰ ভনীজনীয়ে ঘৰত অত্যাচাৰ কৰি আছে। ৰাতিতে ঘৰৰ পৰা খেদি দিম বুলি কৈ মোৰ ঘৰৰ পৰা গুচি যায়। ৰাতি অনুমান 12:30 বজাত চিঞৰ বাখৰ শুনি মোৰ ঘৰৰ পৰা মোৰ ভনীৰ ঘৰত যাওঁ। মই গৈ দেখা পাওঁ যে মোৰ ভনীজনী দেহত জুয়ে পুৰি ঘৰৰ বাহিৰত মাটিত বাগৰি আছে। ওচৰত কোনো মানুহ নাই। মোৰ ভনী আবিয়া খাতুনে কয় যে আসামী ৰুস্তম আলী, জমিৰুদ্দিন, গোলাপফুলি আৰু মালিকা খাতুনে কেৰাচিন তেল ঢালি জুই জ্বলাই দিয়াৰ হত্যা চেষ্টা কৰে। মই মোৰ ভনীজনীক ধৰি চিঞৰ বাখৰ কৰি আছিলো, কিন্তু কোনো মানুহে ওচৰত অহা নাছিলে। কোনোবা মানুহে 108 গাড়ীখনক ফোন কৰাত গাড়ীখন অহাত মই অকলে ভনীজনীক গাড়ীত উঠাই দিওঁ। পিছত গাড়ীখনত তেওঁৰ স্বামী ৰুস্তম আলীয়েও মঙলদৈলৈ অসমলৈ যায়। এই ঘটনাৰ বিষয়ে মই মোৰ দেউতাক ফোন কৰিম মানে সাবসিকুৱেণ্টলি কল দিছ ইজ দ্য মানে এল্ডাৰ চিষ্টাৰ
Of the victim, my lord.
of the victim. Other my lord stated that the time is around 12:30. All stated that when they came, she was lying in the burning. But regarding other it is not regarding dowry demand and all this. The other villagers are not.
My lord, for the
But the statement of the elder girl that the victim herself stated that this poor person, and obviously on the considering the age that mother-in-law has been allowed to go interim bail, and she appeared.
What is her name?
Her name is
Malika
Khatun.
The mother of the present petitioner, my lord.
Here,
petitioner number 4.
In
Malika's case was different.
No, earlier, my lord, this petitioner filed a bail petition before this honorable court. In that bail petition, because of the preliminary stage of the investigations, the present petitioner bail application was rejected. Same one bail application was filed, but the mother was allowed, my lord.
Oh, not in the name, my lord.
But here in the case, my lord, so far the statement.
Only mother was allowed, considering the age.
So far the statement is concerned, my lord. That is the elder sister of the victim, and so far her statement is concerned that the victim was tell her that the present petitioners and the mother of the present petitioners put fire on her body. If that's so, they should immediately lodge the FIR because the victim girl was died on 12, but FIR was lodged on 14th of December 2020. That also in the evening, my lord. It is reflected in the list, my lord. So there was some doubt on the version of the victim, and I have already stated that it is obvious that the family member of the victims and the informant always will support their cases, my lord. So it will be difficult to ascertain whether it is a 304P dowry death case or it is a accidental death. It is not clearly visible at present, my lord, because other independent witnesses who are living surrounding the areas never mention anything regarding the dowry-related person, my lord. So it will be proved in the, my lord, trial. So at this stage, my
There are witnesses that are neighbors.
My lord, other neighboring witnesses they said that Bishwanath শুই আছিল তেওঁৰ বাখৰ শুনি বাহিৰত ওলাই আহি দেখো যে চোতালত গাত জুই লাগি পৰি জখমি মাটিত বাগৰি পৰি আছে ওচৰত কোনো মানুহ নাই that is corroborated with the statement subsequently 108 came. But regarding all almost saying like that,
because whether it is
The
accidental or
question is that why the lady will burn any stove or anything, whatever.
But
in the night around 12:30. Why she will go?
Only
and
as
at
per the-
around 12:30, why she will be alone in the house? Where the other
in
person
the night,
gone? Where gone? Because it is the night, in the night, midnight. A victim lady along with a minor child will stay alone in the entire house, and other family members will be not there. Why? Why they will not be there? Tell me the reason.
In the night,
Anticipative.
what is the
Anticipative.
time?
A lady being alone in the house along with a minor child, and they all will be out of station.
What is the time period between
12:30, that is the time.
Because it happened when someone
Because all were
fired, my
sleeping,
lord.
the neighbors were sleeping. In the night hours itself, it was heard that human cry, and she was, and they came and saw her in.
There is a chaotic situation on that moment, my lord, because and what is the time period between the burning of my lord?
No, we have to go by the ocular evidence at present because there is no other evidence because all the persons came at around 12:30 and saw her.
And the
In
allegation
that
is
condition.
because my lord, allegation is of the dowry that my lord, but nothing has been proved that there is any dowry related issue, my lord.
If not dowry, then 302.
And that apart, my lord, and that apart, one thing.
Not dowry,
And
suppose 302 will come.
another thing is that my lord, because obviously they live, although they live in same compound, but married women, my lord, and they live separately. And the other two, my lord, she is the elder brother and the wife of the elder brother of the husband of the victim, my lord. So at least they may be considered, at least, my lord. If your lordship made up your lordship mind, my lord, at least they may be considered, my lord. Because they are living separately, my lord. Zamiruddin and his wife, my lord, they are Gulaful Nessa or Gulafuli, my lord. Petitioner number 2 and 3. They are, my lord, brother of the husband of the victim, my lord, Rustam. At least, my lord.
What pair of what was department law. That representative they are not the 50% the petition number 1, and they also have a track out of their country that there's no other thing banting against representative they did not demand of them. That the of the may be different in the but there is no other but there is no demand of the to affect it or the other is number 1. When he was free from one structured by the subject or COVID important they are not from the other have not government have not did it and however all came the came to the courtyard of petition courtyard of storm they became in a line the ground with one when but they have how how or fire was for how fire for how fire was for so but it as per the statement of the the all are got who capture her that also they expired the victim they put kerosene over her but it became certain part and all for her but the when he came hearing the cry of her younger sister he found no comfortable the portrait of the and the sister was lying on the ground with her body. Witness of the other sister of here verification record and the treatment of the medical report. So as per the report, that was for the inflammatory part of the body was around 76%.
76%.
Also, from the considering more particular treatment of addiction and other preventive from your petition stands rejected. Oh, sitting. So part that, na?
Yes.
I have already recorded some of the submission made by the most probably by the petitioner side. From the petitioner side, is there any other submission? I think I have recorded, but if any other submission from you, from the petitioner side, any other submission?
Till now, I have completed my submission.
You have completed your submission. Then he will
Yeah.
start.
Yes.
If any reply, you can.
Yes.
Oh.
I think, Lord, I have also submitted my submissions.
Is it? Your submission is also recorded?
I think so.
I'm just checking.
Kindly see.
Oh, yes, yes. You are for the response number 1.
Yes. Very shortly,
Some reason because it was remain as partner.
for the manager perhaps. Manager. For the manager, nobody appeared on that day. And I think today also,
The
manager of the tea state is a party. He has deduced that as this Srinath Das was appointed as nominee, and that was duly authenticated by a short subcommittee. So the amount has been paid. A very little amount is still to be delivered to Rita Das, that is the widow. So that part, due to pendency of this case, that is not provided to me. Otherwise, major part, that is 2,61,950 has been paid to me. And my lord, actually, the petitioner, the appellant has no locus standi, because this Rupjyoti Datta, sister of mother-in-law.
Oh, sister of mother-in-law.
Mother-in-law. So actually, it is not maintainable at all. How she can be the claimant of the dues of her nephew or niece? Nephew, yes. So this appellant has no locus.
And as per them, you are not the married wife, no?
Well,
as per them, you are not the married wife. You are not the wife.
no, they said this, but my husband accepted me. It is recorded in the office record, and I have also admitted. So there, I think they cannot say regarding the non-existence of marriage. When husband and wife says we are married, it is recorded in the office record where my husband served. So this type of claim is
totally unacceptable. Secondly, the mother-in-law's sister, how? He is not even third category of legal heir under Hindu law, my lord. So how she can become an appellant for the unpaid dues to her nephew? So it is very.
May I please your lordship?
Yes. So who is the manager? Oh, manager decoy.
When manager has adduced his evidence.
Achha. He is the respondent of he is not appearing.
My lord, we can list it as 18.
M. Dutta was there for respond number 2.
Yes.
Your for respond number 2? Like you are the manager of the case. Do you have anything?
He has some little commission only.
Huh?
Okay, anyway, let's continue. He is coming.
Lordship, we can list it as 18. There are 3. On 23/6/2006, the General Manager, Dolaguri Tea Estate, addressed a letter to the Assistant PF Commissioner Golaghat mentioning that on 13/4/2006, the due amount of late Dulal Chandra Datta was paid to Srimati Rita Datta, being the wife and nominee of deceased, in response to a letter number so-and-so dated so-and-so of the Assistant PF Commissioner Golaghat, and in the nomination form of late Dulal Chandra Datta, the date of joining the fund 1986 is overwritten, and the signing date of late Dulal Chandra Datta is 10/8/2002 is also overwritten, and the petitioner denied putting of signature in the nomination form by the deceased, and on 28/1/2005, the manager Dolaguri Tea Estate issued a letter in the name of Dulal Chandra Datta, where it has been mentioned the decision of the board of directors to retire him from the service. That person who wrote the name of Dulal Chandra Datta in the letter, in fact, is the signatory in the nomination form, because the style of writing the name of Dulal Chandra Datta is same and similar with nomination form and the letter dated so-and-so. After 4 months of the aforesaid decision, Dulal Chandra died. So here, Lordship, there are some marks, but it is said by General Manager that this was the style of Dulal Chandra Datta. He write in that manner. Some people are habituated. When they put their signatures, they give some marks below or one side. So it is supported, though there is some overwriting, but this was the signature of Dulal Chandra Datta, and that has been admitted. Thereafter, after some month, thereafter on 26/4/2006, the petitioner has sent one petition to Assistant Provident Fund Commissioner Golaghat in respect of wrongful possession of amount of late Dulal Chandra Datta, and the office of the Assistant PF Commissioner Golaghat took initiative in respect of the said letter, but the OP number 2, without discussing the matter with the Assistant PF Commissioner, had released the amount to the OP number 1. On 4/4/2006, Srimati Rita Datta filed a case under section so-and-so against Sri Ratul Burwa and Sri Jiten Burwa, out of whom Sri Jiten Burwa is the son-in-law of the petitioner, wherein Srimati Rita Datta claimed herself to be the daughter of late Daheshwar Datta, and in fact Dulal Chandra Datta was the son of late Daheshwar Datta, and Dulal Chandra Datta had already expired at the time of filing that case, and there Srimati Rita Datta did not mention the name of Dulal Chandra Datta as her husband in the complaint petition. So, thereafter, Lordship may kindly see page 20, bottom may be seen, my lord. From the middle portion, page 20, bottom. OP number 1, Srimati Rita Datta. Lordship has seen. OP number Srimati Rita Datta was the nominee of late Dula Chandra Datta in respect of settlement of the Provident Fund amount left by said deceased husband. But no nominee was appointed by the said deceased late Dula Chandra Datta in respect of gratuity, and that the petitioner is not the sole relative of deceased person at the time of his death. The record maintained in the office of OP number 2 reveals that Srimati Rita Datta is the close relative and legal heir of the said deceased, being the wife and nominee appointed for the purpose of settlement of Provident Fund amount. And late Dula Chandra Datta has nominated his wife, Srimati Rita Datta, and executed the nomination form in her favor on 10/8/2002, last in presence of witness and the manager, Dolagiri Tea Estate, and thereby entitling the OP number 1. OP number 1 means Rita Datta, Rita Das, to receive the full share of the amount of Provident Fund in the event of death of Dula Chandra Datta, to be paid by the concerned authority. The Srimati Rita Datta, the nominee and wife of the deceased Dula Chandra Datta, was paid the entire amount towards settlement of the Provident Fund, amounting to rupees 2,61,950 by check number so-and-so, dated so-and-so, as sanctioned approved by the Additional Provident Fund Commissioner Board of Trustees, Assam Nidhi Bhavan, Vasishta, Guwahati, and as per nomination form submitted by the deceased, the OP number 1, Srimati Rita Datta, is entitled to the full share of the Provident Fund settlement, and the Assistant Labour Commissioner, controlling authority under the Payment of Gratuity Act, Golaghat, white number so-and-so, dated so-and-so, informed the answering opposite party that since the deceased Dula Chandra Datta has made no nomination under Payment of Gratuity Act, therefore, as per Section 4(1) of the said Act, his legal heir Srimati Maisana Datta, mother, and Srimati Rita Datta, wife, will be equally entitled to recover the gratuity, being the legal heirs of late Dula Chandra Datta, and therefore it is contended to dismiss the petition. My lord, here very important question is here. It is said that regarding gratuity, nomination paper was silent. Now, Maisana Datta is the mother of late Dula Chandra Datta. Maisana Datta is the mother of late Dula Chandra Datta. And that is, Maisana Datta is the mother-in-law of Rita Das Datta. Now, Maisana Datta is dead. And her sister is the party here. So how it is, now if even for the sake of argument we say that yes, Maisana had a share in the gratuity, because the nomination paper was silent about that. She is entitled to half portion of the said gratuity amount, but now she is fully entitled to get, because Maisana Datta is dead. And any claim by a third person that so-and-so is dead, so I should be given, it is not permissible in law, my lord. So it is very ridiculous that this person, that is my lord Dugdiri Datta, has come, that I should be given. How it is not only liable to be rejected, in my humble opinion, she should be rather compensated with cost. It should be dismissed with cost. Who is she? What type of inheritance she is as per Hindu law? Now, so far as per Hindu law, can we see what is the let me see. My lord, that is Section 10 of Hindu Succession Act 1956. The property of an intestate intestate shall be divided among the heirs in class 1 of the schedule in accordance with the following rules. The intestate widow, first is widow, or there are more widows than one, all the widows together shall take one share. So if there are more widows, then they would take share according to their share. That means if there is 2 widows, then 50-50 would be divided. So first category widow. Second, the surviving sons and daughters, and the mother of the intestate shall each take one share. Mother, then sons, daughters, and mother. Third category, the heirs in the branch of each predeceased son or each predeceased daughter of the intestate property shall take between them one share. Fourth, the distribution of the share referred to in Rule 3. So Rule 3, among the heirs in the branch of the predeceased son shall be so made that is his widow or widows together, and the surviving sons and daughters get the equal portions, and the branch of his predeceased sons gets the same portion. Now, Lordship, see, where is the mother's sister? Mother-in-law's sister. Dulal Chandra's mother or Rita Datta Das's mother-in-law. So she is nowhere as per Hindu law. And parties are admittedly Hindus. So they are governed by this rule. So, my lord, actually this appeal is not maintainable.
Lordship, not a sister. Petitioner is the daughter of the mother of the deceased, not the sister.
This Maisana Datta? Who is Maisana Datta?
Maisana Datta is mother of the petitioner.
Mother.
Petitioner is not a sister of Maisana Datta.
Petitioner is? Then petitioner means appellant. Appellant?
Yes, Lord. Wrongly submitted.
No, maybe I admit if I withdraw then, but let me be clarified that but on the other day you did not raise this Rupjyoti Datta Borua, daughter of late Doheshwar Datta, wife of Sri Jiten Borua. Now let me see the father and mother of late Dulal Chandra Das. Dulal Chandra's father is where is Dulal Chandra's father is? Where is it?
Okay, no, otherwise
Dulal
you say that she is the sister of the deceased.
Yes.
Sister of the deceased.
Yes.
If she is the daughter of Maisana, then she would be sister of the deceased.
Yes.
I don't know if she is the daughter.
No, that is here. Then Dulal's father would be Doheshwar Datta. If Rupjyoti Datta is Dulal's mother, Rupjyoti Datta is the mother of Dulal Datta.
No.
Huh?
No. Rupjyoti is the sister of Dulal Datta.
Yes, Lord.
No.
She is the daughter of Maisana. Maisana was undoubtedly mother of the Dulal. Mother of Dulal Datta.
Yes.
Maisana is mother of Dulal Datta, was my Dulal Datta. She died.
And Rupjyoti is the sister.
Sister.
Maybe sister then.
Sister of Dulal Datta.
Yes.
No, sister will not get anything. As per Hindu law, just now I have read. So for that portion, that mother-in-law, I would do that because that was my mistake. Because names are very peculiar, and also so many persons, Doheshwar Datta, Jiten Chutia, I don't know why these persons have come. Very simple matter has been complicated. Simple matter is that Dulal Das has died. Whether the Provident Fund amount or gratuity would be paid to the mother-in-law or his father and or mother-in-law Rita Das or to widow. Now the law is very much clear, widow is the first. Now, are you sure? But I have been told that she is no longer here. However, if even she is alive, my lord, she will not get. That is section 10 of Hindu law, Hindu Succession Act 1956 is very much clear. If there is first category of legal heirs, second, third will not get anything. If the first one is not there, then second one will get. Second one is not there, third one will get. Here, first one is here. So it is very simple calculation. But it has been complicated unnecessarily. Now, so far, nominee is concerned, well, it is admitted. Another also say, the committee is there, Provident Commissioner also inquired the matter, found this correct, they paid. Whether High Court can sit over the local investigation, so inquiry made by the Provident Fund Commissioner and some other, there are board of directors are also there. So why they will pay this very little amount, less than 3 lakhs? There is no evil intention of anybody. Everybody has done their duty in accordance with law that was there in the service book of Dulal Datta. So I think, my lord, this honorable court should not interfere and appeal should be dismissed.
May please your lordship, Dulal Chandra Datta expired during the lifetime of his mother. After expired, the respondent number 1 fraudulently received the said PF amount, showing his wife. In fact, she is not his wife. After receiving the said amount, his mother, Maisana Datta, had claimed before the authority and thereafter filed the case before the trial court. During pendency of that case, Maisana Datta expired and thereafter substituted the present appellant. The respondent number 1 had appeared before the trial court but did not file a written statement and not filed any proof that she is wife of Dulal Chandra Datta. If presumed respondent number 1 is wife, then mother also equally entitled the PF as per Hindu succession.
Mother may be entitled, but what about his sister?
Lordship.
Mother may be entitled
Yes.
or entitled
Yes.
under, but what about his sister? The question is whether the appellant, who is
Yes.
the sister of deceased or the daughter of my son and daughter,
Yes.
whether she is entitled. That is the
During the lifetime of my mother, the PF amount released in favor of the respondent number 1 without considering the provision of succession. Lordship. She is also, his mother also entitled.
not denying. But which is whether
During-
the sister is entitled.
After expiry his mother, the present appellant substituted in this case. The respondent number is wife of another, Lordship. She received the PF amount with conspiracy made with the T authority, Lordship. In the nomination form also overwritten. She is not a Rita Dotto, she is Rita Das. In the nomination form there is not written daughter of also. Only written Rita Dotto.
I mean, her proper identification was not disclosed.
Yes, Lordship. The respondent authority did not ask the respondent number 1 to show any evidence as she is wife of Dulal Dutta. Whole fact is conspiracy.
What about you? On the last occasion also for you only it was partner. You're not going to keep it partner, will be hard. Okay.
My Lord, only one simple short clarification, my Lord. My Lord, we can see page 1, my Lord. Page 1. Rupjiti Datta Borua, wife, daughter of late Daheshwar Datta. That means she is the sister of Dulal Datta, and wife of Jiten Borua. This is a very important thing because she hails from another family. She is not unmarried. She is married. And Lordship is aware after marriage, the girl becomes the family member of husband. This is a settled position of law, my Lord. After marriage, the girls become the member of husband's family, not her father's family. So now, sister of Dulal Das Datta or Dulal Datta Das has come before our Lordship, and as per section 10, she has no share. She is a lady of another family. This is common law, my Lord. Everybody, even in Muslim law also, if the girls are married, the girls become the member of husband's family. But if not married or remains a widow, then at that time, some humanitarian ground, she may be considered, sometimes it is considered. So, my Lord, she has no case at all. The unpaid amount, very few, that may be allowed to be drawn by me. Well, that is the respondent.
Rest you have already received. That is GPF and all you have received.
Gratuity. And now gratuity I desired.
Part you made.
Rest of the amount I have already got. Only gratuity, because now if my mother-in-law was there, she could have one share, but as mother-in-law is not there, so this present appellant, Rupjiti Datta, who is sister of husband, has no share as per Hindu law. God bless you.
Any timing? Timing আহিছে নেকি কোনো?
Obliged, my
In this case, my lord, I have filed one additional affidavit showing the new ground of this case, my lord. Then,
He was not dealing, I think.
10. With Honest Cecilia. Honest Das would like to appear. Good, good.
May it please your lordship. My lord.
CS file is item 5 CS.
Item 5, my lord. My lord. In this petition, my lord, I have praying for Jimma of my vehicle, my lord.
Lordship, in this case also, Das have Kamal Parakar Lordship, he have taken the instruction. He is in the legs
He
in
has already instructed. Now, we have received on that day.
Lordship.
In fact, on that day we have received a report from IO that the vehicle is not required for further investigation.
Lordship.
But the question was that your earlier petition was rejected by the court below, only on the ground that considering the report of the IO that it was freezed and the confirmation is yet to receive from the competent authority. That was the reason why your earlier petition was rejected.
Lordship.
So for that reason, we again call for a report on that day. We have kept it on 17 plus 17.
Lordship.
So now they have submitted a report that they have not getting any confirmation from the competent authority.
Then, my lord.
So your vehicle will be released.
Then, my lord, I am entitled for Jimma, my lord.
Yes. That's why we are trying to bring the your what is from your chamber what was appearing.
Lordship, my lord. My colleague was appearing, my lord.
So he was not following us. He is not following. Anyway, number 5 will be able to take. Continue appointee or will be able to. Mr. K. Purva in item number 5. Mr. K. Purva is on its petition. Mr. K. Parasar is on its appearing. It's an application 401 and we are meeting for setting up the enforcing of order date 29/9/23 passed by learned Judge FPC Lakhimpur Lakhimpur, North Lakhimpur in Lalu case number 172/2023. Other section 146, 147, 325, 326, 307, 3, 506, 224, IPC, related section 21 small p, plus 21 small p, plus 29 small p, and the PS Act whereby the prayer for Dima was by the Planning Board. It is submitted by Mr. Purva, the Planning Council for the that during investigation in connected with the above referred case, the so you are the owner or you are also an accused?
No, I am the owner, my lord. I am not an accused, my lord.
Investigation. the vehicle of the present petitioner bearing registration number AS07 BC 1013 Tata pickup van was also seized along with the other seized items. However, the present petitioner was the owner of the vehicle and was not connected with any offence as alleged in the complaint. He accordingly applied for JIPA of the vehicle before the learned
Additional Session Judge FTC Lakhimpur.
An additional Session Judge FTC Lakhimpur, North Lakhimpur, but while order dated
29/9/2023 at page 18.
29/9/2023, the prayer for Juma was rejected, which was rejected considering the report of the eye. Next, right, further submitted by Mr. Bhutta that your vehicle is in custody since 6/9, na?
Since 9/2023.
This vehicle is in custody of police since 6/9/2023. And thus, for a considerable period, the vehicle was in the police custody. And hence, there is the probability of damage of the vehicle if the same is kept further in the custody of the police. Further submitted that the petitioner is ready to execute upon the satisfaction of the court as well as the in the event of granting Juma the custody of the the IOP report was called for from the IO in this regard, and accordingly the same has been received from the IO. It is submitted by Mr. Parakar, the learned chief, that prayer for Jumma was rejected by the learned court people with an observation that the petitioner could not produce any genuine source of money for purchasing the vehicle, which was used for transportation of anti-PS substances, narcotic substances. And it was further observed that there was that the freezing order has already been passed, and it is sent for confirmation from the competent party. With that observation, the petition for Juma was satisfied. However, the IO, as per report of the IO, vehicle is no longer required for further investigation. It seems that from another report of the IO, the confirmation of breathing for the competent operating not yet received. Accordingly, the additional PP, Mr. Parakar, submitted that the certificate is able report from I and it seems that the debate is no longer required for it came back that regarding treating of the present for the order passed by the decision that document not document dated 29/9 therefore Imam Bacon hereby washed directing ignorant court below. Allowing the prayer for Imam while getting to the with regards to the vehicle number AS0750 1013 Tata pickup vehicle furnishing the phone certificate of regarded code below as well as the petitioner is evaluated by the application for IPMA. With file appropriate application before the with regards to your bond will be if the current code below will judge the quantity of the bond. According to the vehicle is departed to the in favor of the after the proper access respectively within the adequate bond to the satisfaction of the court. Further, it is increased intersecting operating between the vehicle, verifying the all stated and ascertaining the ownership of the ownership of the disposal. Okay.
Like May please, Your Lordship. My Lord, I have filed this application for my Lord recall of warrant of arrest, my Lord, issued against the petitioner, my Lord, for non-payment of certain amount of my Lord maintenance, area maintenance, my Lord. Although my Lord, I have been paying the current maintenance amount, my Lord, but there was some my Lord area, my Lord. And since my Lord non-payment of that area maintenance, my Lord, I have filed this application, my Lord, and this honorable court, my Lord, on my Lord 12/3/2024, my Lord. Was my Lord considered this application and my Lord directed to pay rupees 50,000, my Lord, before the trial court, my Lord. Accordingly, my Lord, in compliance of this, my Lord, I have already paid the area amount, my Lord. And my Lord, notice was issued, my Lord, and respondent has appeared, my Lord.
My Lord, the total area amount is 4 lakhs, as of now 4,24,000. On the date of filing of the application, my Lord, the total area amount was 4,74,500. Because the judgment was, my Lord, dated 17/9/2016 and direction was to pay 6,500 per month from the date of the order. From 2022, 6,500 has been deducted from their account. But till that period, my Lord, there was an area of 4,74,500. On the last date, they came and offered that they would pay 50,000, which they have paid, my Lord. All fairness and permitting, they have paid. But there is still an area of 4,24,500. In the petition, my Lord, if my Lord kindly comes to page 7. Here they have offered to pay it on installment basis, my Lord. We have no objection to that also, my Lord. But my Lord may fix the definite amount which they will be paying on installment basis. And their petition may be disposed of.
That will do by learned trial court, my Lord, because all the calculation and all, my Lord, records are there, my Lord. So whatever amount will be fixed by the learned trial court, my Lord, will pay, my Lord, on installment basis. I agree to it.
Only humble submission, my Lord, will fix a time period, stipulated time period within which they will pay the area amount. So whatever amount comes, that the learned trial court can calculate, my Lord. No, since record is not there, my Lord. But my Lord may fix an amount, definite time, my Lord. 6 months or 9 months or even 1 year, my Lord. Up to 1 year, my Lord, we have no issues, my Lord. If within 1 year they can clear this amount, my Lord, on installment basis, we have no issues.
But basically, you filed the petition against
for recall of warrant, my
recalling of warrant.
Lordship. Nothing, at this stage, my Lord, nothing survived, my Lord. Because my Lord, warrant has been recalled, my Lord. I have appeared, my Lord.
Warrant already recalled.
Recall, my Lord. I have appeared, my Lord.
and already paid, my lord, as per direction of this honorable court. My lord, rest of the amount is concerned, my lord. Let both the party will, my lord, appear before the learned court below, my lord. And after ascertaining the entire amount, my lord, whatever they agreed, my lord, or my lord, whatever directed by the learned court, my lord, I will comply, my lord. Certainly I have to pay, my lord.
My lord, my lord will kindly see the order dated 12/3/2022. So this amount of 50,000 which has been paid, they had offered, my lord, and on that their submission that they would be immediately paying rupees 50,000, that warrant was kept at a pay. Now that 50,000 has been paid. Now the list is still surviving in respect of the fact that 4,24,000 is still pending. So in some equal EMIs, my lord, equal monthly installments, my lord, if your lordship is pleased to direct that, my lord, then matter may be disposed of. Otherwise, again, this whole round of litigation will again open. They will again apply for issuance of distress warrant, again apply for issuance of NBW.
At present, your NBW is already recalled.
Recall, my lord. And this is my petition, my lord, this is my prayer, my lord. So far, my lord, whatever he is, my lord, praying, my lord, there is no prayer as such, my lord. My petition will
I am conceding on their behalf. Otherwise, if they want to lengthen this process, my lord,
lordship, my lord, so far calculation he is, my lord, submitting, my lord, that entire calculation is in the record, my lord. Not before this honorable court.
That is also
His submission and his calculation, but definitely calculation will be there as per his submission. Most probably earlier 4,74,000
was there, my lord.
74,500 was there,
There.
and you have paid now
50,000.
50,000. It is accepted. You have paid 50,000. So remaining as per them, not as per
Even, my lord, as per the petition also, this is apparent, my lord.
24,500 is still remaining. And his simple prayer is that equal installment may be the
That is their prayer, my lord. We are only conceding it.
Some installments which may be, considered very learned court will after assessing all
Lordship.
It may be 4,24,000, it may not be, or maybe a higher amount. After the court, it will be calculated in equal installment. It may be given.
Yes, that will do, my lord.
But at present, your NBW is already recalled.
Recall, my lord, I have appeared.
They have clearly stated in the petition that they are willing to pay this amount, my lord, on installment basis, my lord. So
I have to pay,
that
my
effect, my lord.
I think I may not be followed. So I'll pass the order. Yes, your petition is dismissed.
Lordship. Oblige me.
I'm deeply obliged.
Item number 18, I was on late, sir. I am for the respondent number 2. 1818.
You are for the manager.
I am for the manager. My lord, dispute is between the appellant and the respondent number 1. Our stand is, my lord, they are alleging, my lord, appellant alleging that respondent number 1 fraudulently received the provident fund amount of rupees 2,61,915.15 paisa, being nominee and wife of the deceased. That is their main bone of contention, my lord, allegation, my lord. Our stand is, my lord, in our WS, my lord.
50% 18. Yes, your stand is?
My lord, in our stand in the WS, my lord, the proceeding is bad for non-joinder of necessary parties, namely, my lord, Provident Fund Commissioner, my lord, Fund Control Officer, Assistant Labour Commissioner. These were not made party. Because, my lord, we have made the payment as per their instruction, my lord. And we have been very clearly in our WS stated so, my lord. And my lord, one of our...
Who should be made the party?
My lord,
Have you put any
my lord, as the sanctioned or approved by the additional PF Commissioner, Board of Trustees, the Assam Tea Plantation Provident Fund and Pension Fund Scheme, Provident Fund was paid to respondent number 1, that is rupees 2,61,000. So, my lord, as per sanction approved by my lord additional PF Commissioner, we have released the amount.
that we have very clearly we have stated in paragraph 11 of our WF. And we have also, my lord, raised one objection, my lord. The learned district judge has no jurisdiction to determine judicially and effectively the controversial allegations level in the proceeding. And finally, the trial court also come to this finding. And my lord, the fact is, my lord, deceased was, my lord, he given retirement from service with effect from 1st of February 2005. And subsequently, my lord, he died on 1/6/2005. And my lord, the respondent number 1, Rita Dotto, my lord, respondent number 1, the nominee of the deceased in respect of settlement of PF amount left by the deceased. But my lord, no nominee was appointed by the deceased in respect of gratuity. In respect of gratuity, we have very clearly we have stated in our paragraph 7 of our WS. And from the records maintained at the office of the T State, present appellant is not the successor, present appellant, but respondent number 1 is the legal heir of deceased, being his wife, and appointed as nominee by the deceased for settlement of PF amount. Paragraph 8 of our WS. And the deceased nominated his wife and executed the nomination form in her favor on 10/8/2002 in presence of witness and then manager of Dolaguri Tea State. That is also one of our 10 in our WS. And other allegations we have denied. And the Assistant Labour Commissioner, come controlling authority under Payment of Gratuity Act, Golaghat informed the respondent number 2 that since deceased had made no nomination under the Payment of Gratuity Act, therefore as per section 4(1) of the Act, his legal heir, namely Maisena Dotto and respondent number 1, Rita Dotto, will be equally entitled to recover the gratuity being legal heirs. My lord, that is the instruction of from the my lord Assistant Labour Commissioner. But my lord, yes, because my lord, they my lord, both have my lord claimed, my lord, both have claimed the full amount. Therefore, my lord, they even don't approach us also. And my lord, that my lord, the gratuity amount, my lord, gratuity amount is rupees, my lord. My lord may kindly note down 58,739 rupees. And that is still, my lord, lying, my lord. 58,739. And my lord, the trial court, my lord, held that, my lord, the petition is barred by limitation. That is one finding, my lord, barred by limitation, my lord. And my lord, the trial court also held that the Dulal Dotto was a married person and he had his wife was not disputed by the petitioner. That is also one finding, my lord. Lordship will find it, my lord, page 28 of the, my lord, that judgment, my lord. And trial court also found no fault on the part of the T State in making the PF payment in favor of respondent number 1. So, my lord, we have released the amount, my lord, being a nominee, my lord, and as per instruction of the, my lord, superior authority. And that gratuity amount, my lord, that is, my lord, 58 lakhs, my lord, 58,739. That is still lying. Problem. That's it.
So far, I have already done.
Yes.
Lordships, I have filed one additional affidavit, my lord, showing the new ground, my lord, page 20. They have already been married, my lord, and I have annexed one annexer under the signature of the, my lord, Panchayat member, my lord. father knows that both of them got married, my lord. Later on, he filed an FIR, my lord. And lordships, their amicable settlement is going on, my lord. She wants to return to her, to remain conjugal life, my lord. And she is 18 years old, my lord. And she willing to come back to the husband's house, my lord. I have mentioned, my lord. And the son is the only earning member, my lord. Mother is suffering from diabetes. Anytime she has been hospitalized, my lord, so it is very difficult if your lordship will not pass in any order for granting bail. Marriage certificate, any pension is panchayat member. Panchayat member is নহয় আহিব পিছে এতিয়া নকৰিবা আকৌ জেলত গ'লে বিয়াখন ভাঙি যাব
Can you see the 164 statement? Her birth certificate is seized by the police. According to birth certificate, 2004 is the date of year. So from that view, she is measured. But 164 statement, she has deadly implicated the
They fall in love each other, my lord.
The question is, well, the earlier bail application was rejected.
Yes.
We have narrated all the stories of how she was, physically or sexually tortured for the whole day.
Yes, yes.
4 or 5
Yes.
times in a day,
Right.
she committed rape. So these are there. But now the second subsequent application filed by her, because they got married. But
Panchayat, how Panchayat can
No, my lord, she is
marriage
willing to
can be
come back,
held
my
below.
lord. If your
This
lordship
is
will
not, this
not
has no
pass an
evidence
order, my
value.
lord, then marriage
This
will
has
be
no
not.
evidence. They could have gone to the Kaji. They could have obtained marriage certificate
This is
from
also
Kaji.
not false.
So I cannot concede that document, my lord. Panchayat is not the authority to get married somebody, my lord.
It is not a marriage certificate. I have shown that they got married and they were also present, my lord, at the time of marriage, my lord. And FIR also lost later on, my lord. After 1 month, my lord.
after 1 month of what? After marriage?
Married, yes, my lord. Alice, she was staying with husband, my lord. But there was an altercation, then she left the place. That is why father filed the FIR, my lord. That is the incident, my lord. And now she willing to come back, my lord. So if your lordship will not pass any order, then marriage may not be held, my lord, because of that. Because if you would like to arrest, my lord, then again jeopardy they will suffer a lot. Both of them, my lord. Both of them will suffer. Because she is willing to come back. And she is a major, my lord. On that ground, lordship can pass an order, my lord. She is a major, my lord, not a minor.
Her statement is otherwise.
Yes, my lord.
She is a major, okay, but her statement, because as per your certificate of panchayat, whatever the marriage, as per them, the marriage is on 30/6/2023. As per Islamic Sharia, that means the meeting was on 30/6/2020, and prior to that, the marriage was there, as per this one. But if you go by the 164, it's completely different. Marriage is to otherwise you are left apart, but the thing is otherwise also
Well, had there been any certificate from Kazi?
Yes.
Had there been any certificate from Kazi, or the Milord, had the victim come to the court and say that I have no objection, then I could have considered. But at this stage, Milord,
No, another ground is there, my lord. His father, mother is suffering, my lord.
Obviously there, but
Yes.
the question is that yes, does his rightly submitted that he can come and even if she can sworn an affidavit also, he can swear an affidavit that he has no objection, he is staying with her, because now see your petition and your conflict of the petition and the Panchayat's report or whatever is completely different from the
Different,
story.
yes,
exactly.
Divorce.
These are proper
very,
documents.
very it's story.
Well, it will try
She
then.
was
we'll
not
try,
been
try to
kidnapped by the
Since
victim.
she is willing to
She was-
come back, my lord.
That is your submission, but as per the 164, it's completely different story.
Okay.
Completely different story in that she was being kidnapped.
Because of maybe
She
his
was
her
sexually
father, my lord.
assaulted and raped in a 4 or 5 times in a day. So such kind of thing is
No,
there.
they will fall in love, my lord, and they got married.
I don't
that's
know.
why.
Yes,
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 ma'am.
it
As
doesn't
164
say
said,
so.
then she was picked up on muscle power,
Yes.
using muscle power.
It's different, completely.
My lord, this is not a case.
Lordship, kindly give me some time that.
Now see, this petition is pending from your
Yes,
for
yes,
your
yes,
instruction.
yes,
I have
yes.
kept it pending.
Up to your lordship.
It was
then.
fixed earlier on so and so. Then again it was.
Yes, yes. Earlier I was not there, my
I
lord.
was
Recently
then
he
you
engaged
were
me, my
again
lord.
asked to take instruction.
Engaged me, yes.
On the last occasion, you have said that you have filed affidavit, and it was waited. So
Yes,
it cannot
my
be pending for.
আকৌ নহয় নহয় আকৌ বিয়া হ'ব নহয় বিয়া
বিয়া হ'ব
এই এইবোৰ এনেই দেখাই দিয়া গালিয়া লাগি কেনেকৈ সেইটোৱে কথা বুজি পালা
The petitioner had also filed an affidavit.
এই ইহে জানে মোক জানে মোৰ কৃষ্ণ বুজি পাইছোঁ তাকেতো মেৰেজ চাৰ্টিফিকেটখন কৰিব লাগে বিয়া হোৱাৰ লগে লগে
Gaon Panchayat is also saying wherein it is stated that both the victim as well as the accused got married. And it is full stop. Further, it is submitted by MSDB that they got married and wants to return back to her matrimonial house and wants to stay with her husband as the during some the setting FIR was lost by her, and they have already settled things, and she is ready to return back to her. In this topic, Mr. Das considering being is dead, and the present petition also has no new or urgent ground. Consider the very application as urgent on basis of also he submitted that the victim must narrated a complete different story, and there is no difference that he was in love with the petitioner and compared with him, etc. Rather, there is a serious allegation against allegation of rape. Accordingly, Mr. Das demanded in granting the privilege of free respect to the present. But considering the and the record and as per the petition, girl was married at the resident level and she already got married. And and it is with
Namabu as English
her
English
metropolitan house and wants to stay with victim. Another ends with minority victim. That is a completely different story where they brought serious allegations against the victim. And there is considering this aspect of the other implemented method with the nature of delicate.
কিন্তু এগুলো কি মেজর টু এতে হলে
It stands rejected. Your bid.
খালি like
Attempt to.
Lordship, at this stage, Lordship, matter may be fixed for hearing, Lordship. Because
No,
today
Your
matter has come up for admission, Lordship.
Actually, Your Lordship, they are enjoying the stay order since 2022, Your Lordship. And I'm, at present, he has been giving only 1,500. And the order of the family court has already been stayed, Your Lordship, by which 7,000 was directed to the take, Your Lordship.
Order of family court is stayed?
Stayed, Your Lordship, by this honorable court. So,
Anyway, it was the order was on 13/6/22.
Yes, Your Lordship.
So, Lordship may fix for a date for hearing, Lordship, because in this case, Lordship, Mr. Ahmed will appear, Lordship. And
Then
one
Your
matter
Lordship,
is going on in court number 13, Lordship, since morning, Lordship. That's why, Lordship, there is
Who is going to appear?
Mr. Ahmed, Azad Ahmed will appear in this case.
Then Your Lordship may simple price, Your Lordship. And Lordship may keep it for admission, Your Lordship, on 6th of June, Your Lordship. On 6th June, Your Lordship.
6th of June?
June.
Interim order may be continued, Lordship.
So you are enjoying the interim order?
Yes. Lordship may fix short date, Lordship.
Interim order be considered?
Till next date, Lordship.
Yes, till next.
Lordship.
Here in this case, the factual matrix connected to a very peculiar circumstances. I just play the facts, in nutshell. We have instituted an NI case, before the Nalbari court, and that case, went in our favor.
Who is the for the petitioner? You are for the
Yes,
Have a we are going to hear the matter.
Yes, my senior legs in another court, my lord. My senior legs in another court, my lord.
The thing is that, last 10 times, this and that time, ground, this matter could not be prosecuted. And last occasion, at their instance, this matter was fixed today. Now, Lordship, only thing is that because of this delaying, now on account of this pendency of this criminal revision petition, they move application to Nalbari court. That since the application is pending, therefore execution should not be proceeded. And on that ground, my execution proceed now, kept in evidence, my lord. That's time I have been prejudiced.
Now, my lord.
Oh, yes, he is coming.
My lord, the case of the petitioner is that, my lord, there is a delay, my lord. The main case is, my lord.
The main case is still to be numbered, I think.
Yes, my lord. Condonation of delay, my lord.
Okay.
Yeah, my lord, what happened? The basic fact of the case is that, my lord, the principal, my lord, outgoing principal, he has issued several number of checks, my lord, of his own motion, my lord. Thereafter, my lord, when we came to know that the several checks have been issued, so accordingly, my lord, we challenged it, my lord. Honorable Court, at the time of admission hearing, my lord, of the criminal petition, directed us to deposit 20%. So during the pandemic time, my lord, we could not have deposited, but subsequently we have deposited before the trial court. Now, my lord, the condonation delay of some 342 days, my lord, that are to be condoned.
Why your delay is explained in which para?
My lord, I have stated, my lord, why it is so delayed. My lord, lordship, kindly have a look. 443, my lord.
Yes, 440 in which para?
Yes, my lord. Para 4 I have stated, my lord. If your lordship permit me, I'll just read out, my lord. The applicant begs to state the applicant, after passing the impugn judgment and order dated by learned session judge criminal appeal number so and so, approached before the Honorable High Court by filing a criminal petition number on 22/10/21 by criminal petition number by so and so. Honorable Court was pleased to suspend the impugn judgment and subject to the deposit of 20% of the fine amount of the registry of the Honorable High Court. Thereafter, the pandemic restriction with effect from should come across March 20 to September 21 in pursuance to the direct guidelines Apex Code. However, only on the ground of the technical, the Honorable Court wide order was pleased to dismiss the criminal petition and operative part of the order dated so and so. During that
Yes, okay then.
Then, my lord, at next page, my lord, order dated 28/2/22 quoted below. On the last occasion, also he was given last chance to deposit amount of by the order dated 8/2/22. Non-complying with the direction of the court and the admission of the revision, both the petition stands dismissed and common order dated so and so stands vacated. Consequently, both the petition dismissed, return the LCR pending before the High Court since 2/22 for making 129 to delays, my lord. That the applicant begs to the applicant came to know about the order dated from the engaged counsel after 15 days. Thereafter, the applicant, after receiving certified copy of the order, that they apprised about the said order of the governing body of the college for making payment, but due to the paucity of the fund, applicant could not have deposited the amount at the time, and after holding the several meeting and making resolution, making payment of the governing body around 4 months, 120 days thereafter, applicant had deposited the check amount of 20% with the direction on 17/2/22 before the learned CGM. We have deposited, my lord, the 10% as directed by the earlier round of litigation, my lord. College principal in the revision petition before the Honorable Court, and then contacted the engaged counsel, that is me, my lord, and handed over the orders and relevant documents to engaged counsel on so and so. The engaged counsel took 7 days time to complete the draft of the case and filed by the Honorable Court on 9/23, for which the applicant could not approach before the Honorable Court to prefer the instant appeal in time, for the delay of 342 days in preparing the appeal, my lord. I have segregated all the delays, my lord, why it has delayed, my lord. To that effect, my lord, similar thing has been done by the outgoing principal, my lord. I like to show a relevant judgment, my lord. The Honorable Court, my lord, set aside the conviction order in respect of other person, my lord. I am supplying.
We are not on that. Just we are going to dispose the delay one.
My lord. My lord, for gallants, my lord, it is hardly.
Pay your 20% amount.
I have deposited.
Why it was delayed?
My lord, during pandemic time, my lord, lordship is aware, my lord, the pandemic time, my lord, I could not have contact, my lord, my client, my lord. And it was all lockdown, my lord. They could not have come to the Guwahati, despite of my instruction to them, my lord. Before coming to that, my lord, lordship, just for a moment, lordship will see. It will be what is the subject matter of the case. Lordship will come, my lord. If your lordship permit me, just read out some a 3-page judgment, my lord. Similar nature of case, my lord, by the same authority, my lord, outgoing principal, what he did, my lord. And since, my lord, 20% I have deposited, my lord, and without authority of law, my lord, the check was issued by the outgoing principal on the day of last day of his tenure, my lord. Lordship, before passing any order, lordship, kindly have a look this. It will help me, my lord, in my case, the subject matter of the what is the facts of going on there in Nalbari College, my lord. Similar nature of case, my lord. The outgoing principal, he issues several number of checks, my lord. Same thing also been happened. My learned brother is also there in that case, my lord. And my lord, another recent judgment has come from the apex court, my lord. The 10%, 20% deposition is not mandatory. That is totally discretionary, my lord. Whether in earlier round of, my lord, the case was there, my lord, that 20% has to be deposited. Though I have deposited, my lord, 20% before the trial court, my lord. So my prayer before your lordship at this stage, my lord, delay may be condoned, my lord, and lordship will decide on the merits of the case. Apart from that, my lord, they have filed their civil suit also. And it is not the correct provision of law, my lord, or submitted by my learned friend that they could not do execution. What execution they will do, my lord? At the most, they will put me behind the bar. It is the sole issue. If I being a, my lord, principal, now my lord, I am principal, or governing body, if I go behind the bar, my lord, will he get money, my lord? He will not get. No purpose will serve, my lord.
Only I am hearing on the delay part. No.
Yeah, absolutely. Absolutely. There is no necessity to go other side of it. Proceed with the whole issue is about section 5, sufficient cause. And the sufficient cause followed by two principles. There must be a diligence towards the approach and there are some unavoidable circumstances. And second test required bona fide. If suppose these contents remains, my lord, they have a good case, my lord. There is no doubt to that. My lord, here is a case, my lord. Peculiar circumstances are there. Concurrent findings are against them. They approached before this honorable court seeking stay. Stay was granted. Directing to deposit 20% before the registry of Honorable Guwahati High Court, not Nalbari, my lord. Make it clear, my lord. Now, subsequently, they failed. Once they failed, the revision petition was dismissed. Lordship, kindly see, it's a very serious case, my lord, in other way. Principle of law. They sought a revision against revision, my lord. No, I may be wrong, you may make it correct. A revision petition dismissed, my lord. Taking that way, my lord, for a moment. Then what would be the legal recourse, my lord? Suppose whatever grounds they have based in their hand, they could have reopened that revision petition which has been already closed, my lord, because principal res judicata is there. Being functious official, this honorable court pass in order rightly, wrongly. If they agree therewith, my lord, either they go to the, my lord, Honorable Supreme Court or they may come back with an IA to seeking reopen that case, showing whatever reason which has been assigned right now. They didn't do it, my lord. Suppose taken for a moment that this revision petition again be closed down for a moment, my lord. Then they have a liberty to come a third one, my lord. In less litigation, my lord. Therefore, my lord, this will not show a bona fide on their part. Second point, my lord. Why they have filed a revision petition at this moment, my lord? I am coming to this point, my lord. My lord, since their revision petition was dismissed before this honorable court, then we approached before the learned court below for execution. Once we proceeded for execution, my lord, NBW was issued against them, my lord. They came back before the trial court, deposited certain amount of 93,000, my lord. It is their own assertion. I will place the document, my lord, where they have sought certain time to pay the rest amount, my lord. There is not a single whisper that 20% to be deposited, or why 20% deposited civil court, nullby court. There is no such direction for this honorable court, my lord. 20% ought to be deposited, otherwise to the rest before this honorable court. That direction was there, which has been not followed. Therefore, nothing survived. Ins. Now, my lord, once that NBW was issued, my lord, then they have no option left except to take another approach before this honorable court by way of this revision petition, my lord. It is another set of facts which shows their lack of bona fide. Now, lordship, kindly see. Let us test that the Supreme Court says, my lord, yes, per day's explanation is not required, but convincing explanation is expected, my lord. Lordship, here is a case, if we took for a moment, Lordship, just have a look for a moment, their petition, my lord, how it has been designed, my lord. Lordship, I am just saying only one paragraph which struck the mind of this honorable court. My lord, once this case was dismissed in 2022, only to take a decision, my lord, 4 months time took by the governing body, my lord, 120 days. Does it believable, my lord? To take a call, to approach before this honorable court, again back, needs 4 months time. My lord, may I put a question? How this 4 months time is possible to consume only for the purpose of taking a decision? Suppose they have such a situation of issuing NBW, my lord. Immediately that governing body said, next day the decision will be taken care of. Immediately they approach before the learned, suppose the concerned advocate made an approach. Either this approach is wrong, they could have filed IF to recalling of that earlier order. That approach was not done. Even after, my lord, this decision was adopted in after 4 months, another delay is that, my lord, 1/5/2023, my lord. Again, there is a slot of delay, my lord. Big delay, my lord. My lord, if suppose this kind of, my lord, statement is possible to, anybody can design a very good film story, my lord. Question is that, my lord, if it doesn't attract the contention of sufficient goal, my lord, it deserves no value in the eyes of law. My whole case is on the point that if it attracts sufficient court, followed by 2 principles, bona fide and diligent approach, my lord, they have a good case. If this pleadings, my lord, doesn't attract that point, my lord, it has no any value in the eyes of law. First point. Now I am coming to the second point, my lord. Lordship, it is a settled position of law that days of delay should be from the date of cause of action till its filing. Lordship, kindly see how this casual approach. My lord, they have made a delay here, my lord, 342 days. Lordship, note that's a very important point, my lord. The 342 days, in their views, counted from the date of dismissal of revision petition from this honorable court. My lord, kindly see. The prayer of the revision petition to set aside the appellate order of the appellate forum, my lord. The appellate forum passed the order on 26/7/2021, my lord. Can you note down the date? 26/7/2021. And if we count the delay from that day, which is other the part of their prayer, the delay comes to 651 days, my lord. That means what? Explanation is missing. They have pointed out the delay of 342. I have counted these 342s. Even it is also wrong, but it shows from the date of passing order on 28/2022 in criminal. What they want to say, suppose if we take the delay from the date of criminal revision petition, therefore their intention was to take call the recalling of the early order passed by this honorable court. They have not made that prayer. If we look their prayer part, the prayer is exclusively centered and circumscribed only one point, to set aside the order of trial court as much as the order of appellate forum. And the appellate forum order was 26/7/2020. The delay days come 651. Presentation of their in application 342 days. How does it possible, my lord? Suppose in third point, my lord, let us take that delay is not a big issue. Suppose it can be considered on suppose lenient approach or final in any suppose inch of justice. Then what this honorable court do? A honorable court will reopen a fresh revision petition by reaching the discipline, judicial discipline, to give a second thought or call to the decision which has already rendered by this honorable court by exercising power on the 397/401. A same set of facts cannot be covered by exercising similar power at two-stage manner. It will be a dangerous, my lord, precedent would be laid down, my lord. Now, lordship, I am just placing two, my lord, document which is vital here, that how there is a incorrect facts placed before this honorable court. My lord, see, in one hand, they have a statement, assertion on affidavit saying that 20% they have deposited, therefore they have a good case. Kindly see, it is their petition. Is not it a contradictory, my lord? Is not it a case to play in two set of judicial forum in different tune, my lord? They have made a statement there to just to get escape from the NBW, made a statement. Now, relying on that, the delay was the time was granted by the trial court. Not taking the cue of that, my lord, consideration, they come now with another plea before this honorable court saying, since we have deposited 20%, we have a good case. 20% not at all is concerned here, my lord. Simply, you have to place your case that these are the sufficient costs which may or may not be considered. And even it would be considered once they have made an attempt to reopen the earlier revision petition. That because 20% failed to deposit, now we have so their reason that may be reopened, that has to be reconsidered, followed by limitation period, it would be considered, then that would be suppose come, my lord, in a way of, my lord, regular proceeding, my lord. Here they drop it out. Second set of facts, now suppose this will drop it, they will come third, my lord. Then, my lord, what impression it will draw out, my lord? Lordship, kindly see one citation only I would like to place. My lord, it's a very Bhagat case normally referred in all limitation case where, my lord, limitation is a, my lord, two-sided weapon. First, my lord, I am pressing about the part of res judicata, my lord. My lord, this my lord, this Bhagat case 1976. My lord, this says the principle of res judicata is also applicable to criminal proceeding. It is not permissible in the subsequent stage of the same proceeding or in the same other subsequent proceeding to convict a person for, my lord, this is ultimately double zero product part. Therefore, my lord, if you have lost your rights before this honorable court at one stake, you cannot come to reopen the same facts by invoking the same power, my lord. Therefore, principle res judicata is there, rightly, wrongly, technically, not technically, but it reach its finality. Once its finality, my lord, nothing survives. They have only two options, either to reopen that earlier proceeding or to go to the Supreme Court, my lord. Both they have, my lord, left out. Now, lordship, another citation I have given, my lord, about limitation part, my lord, just, my lord, that while considering the part of limitation, the other prejudice of the parties concerned may also be, my lord, taken into consideration. But one citation I have given, my lord, one limitation part citation I have given, my lord. I think both judgment I have placed before lordship. I have given the mark.
Which one?
Yes.
Engagement. Okay. Which one?
My lord, limitation, two citation I have given. One
yes,
is,
now which one is it?
One is res judicata, another, my lord.
Res judicata, yes.
Yes, that is there, I have given. And another, my lord, limitation I have given, my lord. Citation.
Yes. Yes, is that?
Yes. Therefore, my lord, simply saying that, my lord, it gives a bad precedent, my lord. If suppose this limitation will be allowed, this another revision petition, then what happens to the other order that the same forum will not, my lord, disregard to the order which has already passed by this honorable court. Will not be make an attempt to overreach to a decision which has already been passed by the same forum, my lord. It may not be a good precedent. It otherwise gives the impression of breaching the judicial discipline by the same forum, my lord, I think these are the very serious things to be taken into consideration. It is not a such easier case just to give a glance of this limitation part, my lord. Other way, my lord, once that revision petition will be opened, my lord, kindly see the situation. And same set of fact, two judgment will be on the face of, my lord, everyone, my lord. This is my
My lord, to एक मिनट शेष कर लो तुम तो
Response number 2, you know.
Principle.
I will be very precise, Lordship. Basically, the petitioner herein, they have they categorically stated in their petition about the resolutions, and they took 4 months' time. But no resolutions and nothing has been annexed in their petition, Lordship, to substantiate the pleadings, Lordship.
Ex-principal, man. To me, ex-principal.
I'm ex-principal. Secondly, Lordship, the order which my large senior friend is referring, the order passed by a coordinates of this honorable court, Lordship, that order is though similar, but that in that case is not adjudicated. The entire judgment has not been adjudicated in that case. Only a specific part of the judgment has been assailed, and that part has been decided by this honorable court. So that judgment, that order has nothing to do in this case, Lordship. And subsequently, Lordship, the petition filed by my large senior friend, there are so many the actual matrix has been suppressed. The petitioner has deposited 20% of the amount because NBW was issued against them, and without depositing that amount, the NBW was not recalled, which is evident from the orders annexed by the respondent number 1 in their objection petition, Lordship. So my respectful submission, Lordship, the revision petition is to be rejected, and further these points have also be ascertained, as my learned senior friend for respondent 1 has stated, Lordship, that whether a revision petition is maintainable against one revision petition, that is to be looked in.
My lord,
so this petition is to be rejected, which exemplary cost.
My lord, my lord, what happened? The submission of my learned friend, my lord, I have suggested my client, my lord, to register a case against him, my lord. Under what authority of law, my lord, on the last day of outgoing, without the confidence of the managing committee, my lord, he has issued so many checks without knowing, my lord. Anyway, my lord, that I am coming, my lord. On the last occasion, my lord, the Honorable High Court, my lord, did not decide the case on merit. Lordship kindly turn to page 65 of the judgment, my lord, of criminal petition, my lord. Lordship will see for a moment, my lord. Last page. 488 last page of the criminal petition, my lord. Page number, it is in my copy, my lord, 65. Criminal petition. Lordship has come across operative part 28 to 22. Heard the learned counsel of both sides. As it reveals, despite of communication made by the conducting counsel, that is me, my lord, conducting counsel, the petitioner has not deposited the amount as directed at the time of admission of the revision. Petition by order dated 28/10/21. The revision were subject to the payment of such 20% of fine amount. There is no any response from the petitioner's side after admission of the said petition. On the last occasion, he has also given a last chance to deposit the amount by order dated 28/2/22. Non-complying with the direction of the court and condition of the admission of the revision, both the petitions stand dismissed and common order dated stands vacated, stands dismissed and return the LCR. It has not entered into the merits of the case. So question of res judicata does not come. if it is decided on merit, my lord, obviously I would have suggested my client to go for SLP before the Honorable Apex Court. But since the matter has not been decided, my lord, it has to be decided either way, either in my favor or that favor, my lord. Then question of SLP will come, my lord. That has not been decided. Secondly, my lord, I have given one judgment also, my lord. The very principal, outgoing principal, respondent number 2, made an access on the last day of his service, my lord. He issued several checks, my lord. So I have asked my client, my lord, though it is a governing body, my lord, they have taken a resolution to lodge a criminal case against him, my lord. It is a totally misappropriation of the fund, and your lordship has also seen one judgment, my lord, which I have given, my lord, criminal petition. Same very person issuing good number of checks, my lord. And there, my lord, I have made a categorical statement why it has been delayed. It is not fault on my part as a lawyer also. I communicated, the Honorable Court is asking for deposit amount. He said they could not get together for making meeting, my lord. It is not a one person. And now petitioner before your lordship is a governing body of the college, not an individual capacity. Even for a pie, my lord, single pie, they need to have a meeting, my lord. They have to take resolution. Had it been an individual capacity, I would have asked you immediately you deposit. But anyway, my lord, the 20% as sought by the Honorable Court, directed, my lord, that has been deposited. Before the trial court, I have annexed in my petition. So now, my lord, delay may be condoned, my lord, and matter may be decided. And what is the outcome comes from the new criminal case against the outgoing principal. That has to be a question mark, man. A college is the institution, man. Just last day of college, my lord, putting signature of several checks. One judgment I have given, 2 is with me, and other is also there. And plus, my lord, they have filed a civil suit. Civil suit they have filed. They got a decree also. And now they want, my lord, you give me money by any means or you go to the jail. If I go to the jail, what purpose will serve? Because it is a governing body only, man. Principal, my lord. The person who has issued the check, he has been given clean check by the trial court. Said he is retired, his liability does not come any further. Lordship will see the original impugn judgment, my lord. He was been given a clean sheet, my lord. He was acquitted. The respondent number 2, who is the main culprit. He wants to destroy, my lord, the college institution, where, my lord, good many students are pursuing their course. He thought, this is my last day, so let me grab all money. So made a, my lord, conspiracy and issued good number of checks. 2 checks is with me, my lord. One is taken, sir, and if he starts, my lord, some other check also will be there. And there is, my lord, no negligence, nothing, my lord. I have made a categorical statement during the pandemic, my lord, which has issued. And to that effect, my lord, pandemic lordship is aware, my lord, Supreme Court got halt all the cases limitation. So that period, my lord, my learned friend is saying 6 years, 2 months, because in the Supreme Court decision, my lord, is categorically stated, my lord, it has taken so much of writ petition 3/20, my lord. All the limitation from 20 to 20, lordship kindly permit me, my lord, I'll supply. This is all over India, my lord. Lordship may be also aware, my lord, all the courts have been restrained, my lord, cause of action. So from that day, my lord, it will start, my lord. Not from the day, my lord, from trial court order or session court's order. Because Honorable Apex Court, my lord, got halt, my lord, 2002, my lord. That period exempted. How, my lord, 600 days have been counted? If it is counted, my lord, what will happen to the Apex Court direction? During the pandemic period, all the limitation has go off. So, there, my lord, rightly, my lord, some date, whatever we have mentioned in the petition, my lord, for 342. So my humble submission is that, my lord, for meeting natural justice, my lord, the delay may be condoned, my lord, and it will not get affect them, my lord. Why they are so adversely and badly, my lord, for this person they go behind the bar. That is their motive, my lord. And now Lordship has seen the respondent, my lord, outgoing principal, instead of supporting the college, he is supporting the another person, my lord. Without doing work, my lord, they want to grab money. So considering...
Delegation or, my lord, in this kind of situation, my lord, then we have to, my lord, make counter.
Just a
case
minute.
of limitation, my lord.
Yes, sir.
Yes,
You got your ample chance. My lord, I am saying, why you are so worried? I am saying about respondent number 2. Why you are so glad? Tell us.
Not, my lord, if suppose this kind of word would be used, my lord, then I will...
My lord, I am using what against the outgoing principal, my lord. He has committed fraud.
Simply saying limitation, yes, my lord, he has a right to say. But same thing is repeating, my lord.
May I submit, Lord?
Already submitted everything, my lord.
My lord, they have submitted...
My learned senior friend is alleging that the respondent number 2 has committed fraud. But the apparent from the documents it shows, I have issued a check, and after issuing after almost 2.5 months, the check has been deposited. But that is not on my hand. And all the checks has been issued after resolution passed by the governing, which is rightly placed before the learned court below. And that's why the learned court below has given the principle to the retired principal, because he has rightly established this case by supporting all the resolutions.
That subject matter is not yet concluded, my lord. Because, my lord, I have instructed my client to draw a criminal, file a criminal
They may
case.
file several number of cases. There are several number of criminal cases are pending against me filed by respondent, and even I should not submit, your lordship. But since they are alleging me, I had to. My son has been ousted from the college. That has also been done by the present principal. Several requisitions are also pending.
They are not on that.
We are, my lord, only condonation of delay, my lord.
There are two cases, my lord. 443 and 455. That's the next. There are two judgments which have been pronounced.
Yes.
There are two
under one
and item, 11 items, my lord, can you see, there are two mistakes.
There are two delay petitions also. Two criminal revision petition has been filed.
455 and
one is
453.
My lord, two criminal petition, my lord, because of two cases.
Both may be disposed of. Similar matter, only that checks amounts are different.
Checks amounts are different. There is two cases.
IA 455 and IA 443.
For IA 445,
and IA,
is there any filing number for criminal?
No, my lord. It is has to be condoned then only, my lord.
No. Filing
yes,
number
yes,
is
yes,
there.
yes. There is a
Filing number is serial number is there, my lord.
Yes,
470823
and 472123.
Filing number is there, my lord. No, duta hobo tate.
I think
Showing one only.
Yes,
But record is there, my lord. So, my lord, my prayer is that, my lord, since your lordship has seen, my lord, what is the intention, there is no any malafide or nothing, my lord, latches on our part. Being a governing body, my lord, the delay may be condoned.
That is the filing number.
One is
Other one
4721
is
and
IA
another is
455.
IA 455 and IA number. Are IA bhai.
But IA 455.
Lordship, I will give that, my lord.
But we don't have IA 455. IA 455 with the filing number we don't have.
My lord, we right now.
4708 is the filing number.
One is 443, my lord.
470 is with 433.
Then
433.
4721.
Another is 4721.
Serial number.
I think it has not been put
The other one is
4721.
21. 23. Filing number.
4721.
There is the same set of facts. Now the checks are different. That's why
2023. In that case, what was the delay?
Same.
For
judgment was pronounced same day.
Same day, my lord, both the case were.
Two checks, therefore two judgments.
Same, my lord, same common judgment.
So then IA 443 and IA 455.
455. There is two IA, my lord.
My lord.
Judgment is on.
All right.
Eleven, 12, these are all together, na?
Yes,
11,
item 11.
11, 13, 14, 15.
59 for the. I am for 11.
Except 12.
12 is over.
12 is over. So 11, 13, 14, 15, and 16. 13 is over. 13 is okay. 11, 14, 15, and 16.
At 2 p.m.
P53, my lord. Basically 307. Sir. Police file a case. Your lordship will find the FIR, my lord, page 8.
Page 8.
Page 8. Total 24 persons named in the FIR plus others. I am number 4. My case is, my lord, that I am a day laborer, my lord. I was at home. An accident took place in front of my house. Regarding that accident, my lord, regarding 2 vehicles, some dispute and some quarrel took place, my lord. On hearing hue and cry, I have gone there. This is my fault. Now I have been named there. Page 8 is the FIR Annexer 1. I have the honor to state that around 11 a.m. on 1/4/24, when I, the traffic in charge, so-and-so, was taking necessary action at the place of occurrence at Jagmari, Part 4, on the basis of information received by GD number so-and-so, below cited accused persons, in furtherance of the conspiracy, came to the place of occurrence in a body and violated the law and order at the place of occurrence by resisting us from discharging our lawful duties. With the intention of killing me and my colleague, they pressed our necks, dealt punches, blows with the branches of tree on various parts of our body, and thus caused injuries to us and tore my uniform. The accused person resisted the movements of vehicle, tried to set fire to the vehicle bearing register number so-and-so, involving in the incident, in houses using filthy words. That was the question. Now, so far the contents of FIR, my lord, I have nothing to say. My question, my lord, since I have stated categorically, incident took place in presence of my house. There are 2 vehicles. I do not belong to any of the vehicle, my lord. Vehicle it belongs to some other person, my lord. Now the question, my lord, my name is there because subsequently I have gone there. One here because in presence of my house, my lord. This is my involvement. And in time what I was there, my lord, I appeared, my statement also recorded, my lord. On that, my lord, my prayer is that your lordship, subject to my lord and friends, my lord. Since already he is cooperating, investigation of this statement recorded, and there is nothing adverse against him, my lord. On that ground, your lordship may make the interim absolute. This is my prayer, my lord.
He is on interim, Milord, and he has appeared before the IO. Basically, this is a case of Milord mob lynching. The police personnel went to see the Milord accident occurrence, and Milord here public gathered, and Milord some witnesses have been examined, but no personal attribution is not there. They say yes, the occurrence took place. Police personnel, if the informant was not beaten up, his uniform was torn. But the personal attribution is not good. People who has done. Many people gathered.
In presence of public platform, so my lord,
perhaps there is no grievous injury. I do not know. Injury report is not there regarding that. Otherwise, section is 25.
Pressing of neck and all these are things.
Yes,
That's why most probably 307 is there.
The witnesses say, no arms have been used. Kill, gusa, punching.
My case, I think, he is cooperating, he is already appeared.
These statements are
specific attribution is not there, man. He is there, nothing to do with. No, none of the vehicle belongs to him. Man.
item number 11. By your
Ayu Chaudhary.
Ayu. It's an application. City receipt, benefit, address. It is selected that if the representative as a result, it's the fact that after an accident, the human right when the police person arrived at the human right when the person arrived at the spot and think that into that would be comma it doesn't fit when there but he has to name it the file it falls however it has already appeared before the eye after obtaining it and cooperated in the investigation. His statement is record. He completely moved his eye for a granted to take. Next time it's contact Mr. Dutt. Planet that you submitted that it doesn't fit about open at any there is no implementation which was taken. So it was a case of case where some person present in the place of occurrence, right? Some person after the accident or it is something that's to be considering get that packet contact that for exit order is of 24/4/2010. Okay, your interim is that.
Obliged, Your Lordship. He did not appear further, but already appeared.
Also, my lord, same. He has appeared.
My lord, I appeared, my lord.
She has appeared, my lord. She is a lady.
Ladies, my lord. My lord, my case is that, my lord, I was, my lord, supplying water in my nearby paddy field, my lord. After hearing one cry, my lord, I went to the place of occurrence, my lord. So she then said, that is my fault, my lord. But personally, I am
at a relevant time. What were you doing?
My lord, supplying water in the nearby paddy field, my lord. My paddy field, my lord. After having interim, my lord.
The commission more or less will be same.
Same. But one thing, 15, so far item number 15 is concerned.
No, we are on item number 13 at present.
14.
Oh, sorry, item number 14.
14 more or less same. The C has also appeared before the IO. Her statements are recorded.
It will be disposed of. An accurate order was on 205. Your order, interim order is made.
I love it.
I look at the item number 15.
So far 15 is concerned, my lord. I have not found your statements. And my lord, orders copy, interim orders copy is also not submitted to the IO.
That means you have not appeared.
Perhaps he has not appeared.
Appeared, but I don't know whether.
When did you?
The interim order was passed on 3/5.
Passed on April.
3rd of May. In the particular from
30 April.
3rd of May. There were two petitions were there.
And 10 days.
Case there is updated up to date, Milord, till 18/5.
Oh, then it's updated. Then we are not there. Your
His statements are not there.
My instruction, they appear. I don't know whether the statement is recorded, Lordship. To that effect, I have no instruction. But they appear, Lordship, 10 days time were given, on 9 days they appear.
No, they appeared is a matter of fact. The question is that your bail order is also not appeared.
Yes, that is not. But further, Lordship, one time may be given. If they did not appear, Lordship, I will ask them to appear. My instruction on the 9th day, Lordship, they
Because it is updated up to 18/5.
18/5.
So 18/5 is already there. It is the order of 3/5 only.
3/5. My instruction is that on 9th day, Lordship, 10 days were given. On 9th day, they appear.
It is but submitted by Mr. Raj.
Or your Lordship may dispose of with the direction.
Well, one second, sir.
Is it there?
No, Monul Haq.
Monul Haq.
One is Monul Haq, one
Ziarul
is
Haq.
Amanul.
Ziarul Haq appear. Ziarul is son of this.
Who is Ziarul?
Monul Haq.
Monul Haq.
Ziarul is not there, Jalko.
Jalko.
He is Jalko.
Ziarul Haq 19 years.
Jalko and alias Enamul Haq.
Monul Haq's son appeared, but he is not.
Both are father and son. Yeah.
Son of Moinul is Jalko alias Armanul.
My lord.
He is the son of Moinul.
My lord. One thing, let him appear more or less, otherwise evidence is there. My personal attribution is not there against anybody. So, let him appear. Otherwise.
How about the is ready and that he is not able to take it when he used additional food. However, he is responsibility maybe to complete it that it's in that way against none of it, but and then we have further as per the instruction of the type, the OT appeared before the I on the 9th day of bail, and the statements are recorded. However, he submitted that the statements are not recorded. Both the statements are appeared before the I and the before. Another the interim business split order against the to appear before the I did 7 you within 7 days you appear before the IO, and otherwise your
yes, that condition may be given. Obliged.
Dispose of it?
Yes, yes.
I am appeared, Your Lordship, after untim bail, Your Lordship.
Yes, he appeared below, his statements are recorded.
You are Amjad.
Lordship.
You also
resident
obtained the pre-intercessory bail on 3rd of May.
Lordship.
Yeah. What is your plea, whether you were there?
At that time, I was working at my vegetable garden, Your Lordship, which is nearest to my place of occurrence, Your Lordship, my home.
and really
Obliged.
Lordship, on the last occasion, I had already made my submission on behalf of NF Railway.
Oh, yes.
Yes, Lordship, only just recapitulate my point of argument. Only 5 minutes I will take before this honorable court.
More or less I brief is not done by me. So now you want to submit any
I recapitulate, Lordship.
Okay, okay.
I recapitulate so that Lordship will aware of the fact. There is a consignment, Your Lordship. That consignment is start from the Rangapani to Bajbas. That point of jurisdiction, Your Lordship.
Yes.
Lordship is very aware of it. The Rangapani and the Bajbas starts under the jurisdiction of West Bengal. At the point of the railway claims terminal, our point is on the point of jurisdiction. That starts from there to there, the Bajbas. And there is a contract agreement between the tripartite agreement between NF Railway, State Bank of India and Numaligarh Rupate, whereby it has been mentioned that any dispute arises, it will be mutually agreed between the parties. Now, on the said judgment passed by the RCT, Railway Claims Tribunal, where it has been recovered that to repayment the amount of rupees to the petitioner for amount of rupees, Your Lordship, 651 lakhs, 252.
51 lakhs.
51 lakhs, 0252. Now, my Lord, the petitioner's contention is that, Your Lordship, that since Bajbas is the railway-owned terminal station, and that have been slided to some another private sliding, and if it is sliding from another portion, railway cannot take any recovery of that terminal charges. That is their basic contention. As per the circular passed by our railway claims, Your Lordship, that claims says that there are two sections. Section 64 is the forwarding report, Lordship is very aware, and section 65 is the railway receipt. Forwarding report stated by the consignment that whatever the statement will be given, that will be forwarded, and all the details will be whatever they want to give in the wagon, in the M2 wagon. And thereafter, after being inspected, Your Lordship, the railway will give the railway receipt. Now the question is that if more than the weightage, everything, if any chaos comes out, in the overweight, due to the weightage, due to the electronic waste system, Your Lordship, it will be detected if it is more or less. Now here in this case, Your Lordship, the Bajbas is the station. Thereafter, the consignment has been done from in the forwarding reported up to Bajbas, not up to the another station. Lordship is very aware of the fact. Now, on the basis of this forwarding reported, on the 50 numbers of wagons, Your Lordship, every wagons, the railway receipt has been issued. That consignment every wagon. Then that railway receipt which has been issued, Your Lordship, is not from this Guwahati NF Railway. It is the part of the Eastern Railway. Now, any dispute if arises will be executed before the jurisdiction of Eastern Railway. That is the point, Your Lordship. Now, what the petitioner contention, of respondent contention is that since we paid the money to the Guwahati jurisdiction, everything will be trial before this honorable court. That is their contention. We said, and the affidavit which has been filed by the Numaligarh, Your Lordship, they also categorically stated that it is under the jurisdiction of West Bengal, not in the NF Railway. The money which has been transmitted to the SBI, to the NF Railway, that has automatically transmitted to the Eastern Railway. That is a system called Integrated Management System, IMS. That is
there's an electronic device that have been propounded by the NF Railway, Your Lordship. Now, this IMS is only for the purpose of to expedite the process so that before reaching the destination, the money can automatically transmitted to the from originating station to the destination station. That is the point, Your Lordship. Now, the point is that, Your Lordship, as per the circular of Annexure 4 I have mentioned, Your Lordship, 29/10/2010, that circular says that we are railway only confined with the two sections, on the periphery of the two sections. Under section 64 is the forwarding report, and 65 is the railway receipt. And this prima facie 65 is the prima facie of the railway documented evidence. On the basis of this consignment, Your Lordship, the railway has issued the receipt, and accordingly, the whole transaction has been done. Now, railway cannot take any charges which is not beyond the jurisdiction of the railway terminal. Now, terminal charges which are beyond from the private riding cannot be taken by the railway, but there is a circular in the record. It shows that there is a percentage beyond this jurisdiction also. Assuming, Your Lordship, if Bajbas fails to deliver this as a servicing agency, Your Lordship, if I go to some another station on the instigation of the respondent side, not from my side, because you have mentioned in that particular plot on that point. Now it is dependent upon the intention upon the petitioner to where you have to be delivered. Since you know very well the railway doesn't have in that portion, but we are confined up to the 2 point, Your Lordship. Section 64 is the forwarding report and section 65 is the railway receipt. On the basis of this, Your Lordship, in the circular which have been mentioned in the circular 31 of the 2010 Annexure 4, that is a pinpoint. It has been categorically mentioned we can levy the charges up to that limit. Now, beyond that limit, it has been mentioned in the record, Your Lordship. I had seen in the record book. It is maybe in the page 50. That record says, Your Lordship, what is the railway cannot go for the extra services for that point of time. 147A, Director, page 50, 298. Mung dekhai dok, mo dekhai dok. A little bit better for me because. এটা হৈছে 298 নহয়, 298 section 298 ne 218 আছে জানো flag already flag mark has been done here.
Flag is there.
That is pinpointing that assuming if railway has to go beyond the jurisdiction which is not the periphery of the jurisdiction of railway receipt or forwarding report, and what is the search? What is the search? It is alternative search. What have to do? This remedy has already been mentioned in there. It is in the record, Your Lordship. So my humble submission before this honorable court, it is not a case of, Your Lordship, for a day. It is a consigned part for the 3 years. Subsequently, it has been continuous process. Assuming if railway has done a committed mistake, only one set of event, then it can be considered that this is the fault of the railway. It is a negotiation instrument between the parties, Your Lordship, that it is not a case of one day. It is a case of around 365 days into 3, which is around 1095 days. So it is a mutual tax between the tripartite agreement between the SBI and the whole transaction which have been done, Your Lordship, is not in a single day. That is my point, Your Lordship. Assuming one railway receipt that can have been committed mistake, that can be done, but it has been repeatedly been done. It is my burden of proof to show that why you have been so raised up to Bajbas, not to other stations. It is a part. So my humble submission that may be also be recorded on that basis, Your Lordship, entire argument of a tripartite argument have been silent of this RCT judgment, lower court judgment. There is not a single space on that point of issue that why tripartite agreement is required. Last submission, Your Lordship, that is my contention is there under section 64, 65, and the money which have been paid under section 10 of the Railway Act, Your Lordship, the moment the amount which has been paid from originating station to destination station has automatically disbursed to the East Bengal, not in NF Railway. Because on the issue on the point that your lordship, since Eastern Railway is the sole authority for issuing the railway receipt, it is not a part of the NF Railway has issued, your lordship. It is a part of the Eastern Railway. Assuming, your lordship, if the train has been derailed for in some occasion, now who will take the responsible for that? Eastern Railway. Railway receipt is there. And tripartite agreement is there, and where it has been closely mentioned about the agreement. Last point, your lordship, in during the course of argument, your lordship, this honorable court has pinpointed me regarding on the arbitration clause. Is there any possibility of to be settled by, since two government stakeholders are in the same window system, can it be done in a single window system, that is Union of Government, Union of India? Is there any provisions of arbitration? Yes, there is a clause of arbitration. In that point of time, our railway has not defended on the arbitration clause, since only on the point of jurisdiction. But still, your lordship, during the course of argument of this, before this honorable court, we have filed our affidavit by the two affidavit, one on your lordship 18 June and another file on 13 February 2017. Two affidavit filed by the railway. In that affidavit, we have categorically mentioned there is an arbitration clause whereby it can be co-initiated with the arbitration clause if it requires. But still in the preliminary stage, we have not initiated the invoking the jurisdiction of arbitration clause, so it is left to the court to decide, your lordship. That is the. And so far, your lordship, last our justice, one Justice Rumi Kupan has categorically mentioned about the death charges 100 MFA 100. That squarely covered his judgment. That is my point, your lordship. And one Supreme Court judgment says one day, I have already mentioned here also. That Supreme Court judgment, it has been mentioned that I want to say 2021 4 SSC 379. That has been there, voluminous. The Supreme Court says where there is an invoke of arbitration clause, the writ petitions or any other 227 cannot lie. That is the last part of the paragraph of the judgment passed on the here. In the paragraph 55, there is a paragraph 55 and 55.1. It has been observed that when there is a case of invoking of the jurisdiction of arbitration point, where there is an arbitration clause is there, although the petitioner has silent on that part, court has a so motor to go invoke on the jurisdiction point. That is my humble sir.
Wait later. Lordship, in this case, first of all, I would like to read the judgment of the Railway Claims Tribunal passed in OA number 127 of 2015. It is at page 39 of the Memorandum of Appeal. And 40 is the relevant part. In the tribunal, my lord, there are mainly two issues involved. First, the jurisdiction, that is whether the Railway Claims Tribunal Guwahati has jurisdiction to deal this claim application. Second, whether the applicant is entitled to refund of freight overcharge. So these two issues were dealt by the Railway Claims Tribunal, my lord. So I would like to read from the beginning, my lord. Lordship may kindly peruse page 40. It starts from, this claim application has been filed under section 16 of the Railways Act 1987 by the applicant for a recovery of freight overcharges on account of wrong collection of destination terminal charges, total rupees 66,25,200 along with interest and cost of litigation. Here, my lord, we prefer claim for destination terminal charges. Two types of charges are there: originating terminal charges, which will be recovered at the time of booking. So here, booking station is Numaligarh Refinery siding, that is at Rangapani, So it is their own siding, so they have not levied any originating terminal charges. So we are not on that, my lord. But here destination is Bajbaj. As per them, Bajbaj is a railway station siding. So as per the relevant circulars, so the destination terminal charges is justifiable for according to them. So our contention is this destination is not Bajbaj. It is the consignment was delivered in the siding of the BPCL, Bharat Petroleum Corporation Limited, and the same aspect is recorded in the railway receipt. They have clearly mentioned that the consignor is Numaligarh Refinery siding and the consignee is Bharat Petroleum Corporation Limited. So, my lord, para 2 says, according to the applicant, all the 50 train load petroleum products loaded from siding known as NRSR, RNLR, this is the short form, my lord, Numaligarh Refinery Oil Siding, and as such, levy of destination terminal charges are not at all applicable, and railway at booking point cannot demand and collect any terminal charges on account of booking point. According to the applicant, in all 15 train load consignments of petroleum products were booked to destination station Bajbaj, and all the above noted 50 consignments were delivered in the private siding at Bharat Petroleum Corporation Limited, known as MHBS. MHBS is a station code, my lord, served by station Bajbaj. But booking station NRSR Rangapani collected terminal charges on account of destination station, which was wrong. According to the applicant, in all 50 train load consignments, the freight money was paid at Maligaon, Guwahati, as per agreement dated 1/7/2010, and as such, applicant is legally entitled to demand and claim refund of freight overcharges collected by the railway on account of destination terminal charges in this transaction, and pray for decree of the case as paid in his claim application with cost and interest from the date of overcharges. Both the respondents have filed their written statement without any supporting documents and made general denial in the written statement. Respondents Railway pleaded that Railway Claims Tribunal have no jurisdiction to entertain the above claim application as the consignment was booked from NRSR RNI, a private siding is situated in West Bengal, and pray for dismissal of the claim application. The applicant filed prayer for discovery of documents by prayer dated 23/11/2015, and the same was allowed by this tribunal by their order dated 26/11/2015, directing the respondents Railway for production of demanded documents and information. In spite of the above directions of the tribunal, the respondents failed to submit any documents and information. Applicant prayed before the Honorable Railway Claims Tribunal to take adverse view on account of non-submission of vital booking and delivery of documents for proper adjudication of the case by the tribunal. Applicant also submitted affidavit dated 19/11/2015 and enclosed therewith RTI information collected from respondent number 2, indicating that all the 50 train load petroleum products were delivered at private siding at Bharat Petroleum Corporation Limited siding, MHBS DGB, which is not a railway siding. On perusal of the case records, we find that by direction order dated 8/1/2016 and 18/2/2016 to the respondent railways was directed to inform the court about the delivery place. On the basis of the pleading of the parties, the following issues were framed. Number 1, whether the RCT Guwahati has jurisdiction to deal this claim application, whether the applicant is entitled to refund of freight overcharge as claimed in his claim application. Number 3, relief and cost. Our findings on the issue involved are as under. Issue number 1. At the time of hearing, it is admitted fact between the parties that the freight money in all the 50 train load petroleum products was booked from NRSR RNI station of NF Railway was paid at Maligaon, Guwahati as per agreement with NF Railway Administration dated 1/7/2010 to State Bank of India Ganesh Guri Commercial Branch, Guwahati, which is situated within the campus of NF Railway Maligaon Railway Headquarters, and payment made in the name of FANCAO NF Railway Maligaon, which falls within the jurisdiction of Honorable RCT Guwahati. That on perusal of RCT Procedure 1989 Rule number 10, which is reproduced hereunder. Rule number 10. Place of filing of application for refund of fare and freight. An application in respect of a claim for refund of fare or freight referred to in clause B of subsection 1 of section 13 of the Act may be filed before the bench having territorial jurisdiction over the place at which such fare or freight was paid or the place where the destination station lies. Here, my lord, the rule number 10 says that we can file application if, my lord, the payment was paid, freight was paid at the time of booking, my lord. So here the payment was made at Maligaon. So as per this rule, my lord, so we have the jurisdiction to prefer this claim application, my lord, or the place where the destination station lies. So, my lord, accordingly we filed the claim application as per this rule 10. Since in the case under discussion of freight money was paid at Maligaon is admitted fact between the applicant and respondents, and as such, Honorable Railway Claims Tribunal Guwahati has the jurisdiction to adjudicate the case and administer justice. As such, this issue is decided in favor of the applicant. Issue number 2 and 3. At the time of hearing and perusal of the respondent's RTI letter dated 21/9/2015 and 21/2016, it is admitted fact between the parties that all the 50 trainload petroleum products were delivered at private siding at Bharat Petroleum Corporation Limited, siding, MHBS, and admitted that refund of destination terminal charges in terms of Railway Board Circular number dated 29/5/2007 read with Railway Board clarification dated 77/2007, which we reproduced hereunder. So this is the contention of this circular dated 29/5/2007 and 17/7/2007. After that, my lord, Lordship may kindly come to the order part. Accordingly, on the basis of the pleadings advanced by both the parties, my lord, the tribunal decided the entire two issue, my lord, in favor of the applicant. First of all, the jurisdiction issue is decided on the basis of Rule 10, my lord. Rule 10 says that if Lordship freight was paid at Maligaon, then, my lord, we have the jurisdiction to file this claim application before the Railway Claims Tribunal, Guwahati. Now, my lord, first submission made by the learned counsel for the appellant is that, my lord, jurisdiction. They are saying that in our affidavit we have clearly admitted the fact that both the railway, that is Bajbaj and Rangapani, is in the Eastern Railway. It is correct, my lord. Both Bajbaj and Rangapani is in Eastern Railway, but, my lord, the payment was made at Maligaon. And as per the rule, my lord, it clearly says that if the payment was made at the place where the payment was done, my lord, at the time of booking, so the jurisdiction lie over there, my lord, the place where the payment was made. And this aspect is rightly dealt with the Railway Claims Tribunal, my lord. Secondly, my lord, they are saying that this matter should be referred to the arbitration. My lord, first of all, they did not take such plea before the Railway Claims Tribunal. Neither they have made any prayer in the appeal, my lord, regarding arbitration clause, my lord. Despite that, my lord, the Honorable Court, by order dated 31/8/2016, passed in IA Civil number 1171/2016, made a query that why, despite the existence of arbitration clause in the contract agreement, no plea under Section 8 of the Arbitration and Conciliation Act 2015 raising the plea of jurisdiction was taken by the railways before the tribunal. So this instruction has not been received till date, my lord. They cannot prove that why, despite of this arbitration clause, they did not take such stand before the claims tribunal. Because as per them, my lord, tripartite agreement state that if there is any dispute between the parties, then they mutually settle the dispute or they may go for arbitration, my lord. But in spite of this clause, my lord, why they not take such stand before the claims tribunal? Now they are simply fill up the lacuna of their part, my lord. They are just simply trying to override the mistakes of their counsel, my lord. Now they are making their stance that despite this arbitration clause, the matter should be referred to the arbitration. So this issue is, my lord, not maintainable at this stage because the Honorable RCT has the jurisdiction to decide this matter for the refund of terminal charge, and number of cases were pending, my lord, before the Railway Claims Tribunal as well as before the Honorable High Court, my lord. So the Honorable RCT already dealt this type of issues. So this type of submission cannot be entertained, my lord, at this stage. Second thing is, my lord, the place where the consignment was delivered is the place owned by the consignee, that is Bharat Petroleum Corporation Limited. So in the RTI information which we have obtained from them, my lord, the Eastern Railway, they themselves admitted that the consignment was delivered at Bharat Petroleum Corporation Limited siding. So which lordship may find at page 154 of the LCR, as well as lordship may also find 154 first lordship may kindly see 154 and 255.
Page of which?
255 lordship may kindly peruse 255.
255 of the
LCR. There are two RTI information which we received from the Eastern Railway. One is at page 154 and 255.
You want 255, no?
First 155. Or 154, my lord.
154.
54.
Yeah.
Doctor, got it?
Yes.
Lordship, here it is mentioned that reference above this for your information that all the petroleum product account NRL were being unloaded at BPCL siding Bajbaj, booked Rangapani as annexed in your letter. So, my lord, this letter was issued by the respondent number 2, Eastern Railway, and now they are claiming that it's delivered to Bajbaj. So, the terminal charge is levied correctly, my lord. But here they clearly admit that this consignment was delivered at Bharat Petroleum Corporation Limited. This station, Bajbaj, is a serving station, my lord. But the fact is, consignment was delivered at Bharat Petroleum Corporation Limited. Another information, lordship, is at page 255. Same information they have confirmed on 21/9/2015. And there is no rebuttal, my lord, with regard to these two documents, my lord. They have not denied that this consignment was not delivered. So, as per the circular dated 31/3/2010, my lord, which they have annexed in their memorandum of appeal, if the consignment was delivered at private siding, my lord, the terminal charges shall be refundable. It is their circular, and I am relying on that circular, my lord. Their circular is at page You can see from my file, my lord, it's not there. This is the circular, lordship. It is issued by the Railway Board, and this circular simply says that if the terminal charges, if the consignment is booked from the private siding and delivered to the private siding, then the terminal charges shall not be leviable. But if it is booked from the railway siding, then terminal charges shall be levied. And in the present case, both the stations are private siding, my lord. And the information which we obtained from the RTI, it is also admitted that yes, the consignment was delivered at the siding of Bharat Petroleum Corporation Limited. So the issue is very clear, my lord. The terminal charges shall not be leviable in terms of the circular issued by the Railway Board. So it is an admitted position between both the parties, my lord. And on the basis of the admission, the learned tribunal has passed the order, my lord. This circular dated 29/10/2010, lordship may kindly see from the LCR also. It is there, my lord, at page 231. Lordship may kindly see from the LCR also. It is there. The case is very simple, my lord, and there is no point to refer the matter before the arbitration because this stand was not taken by them at the time of filing of the written statement, my lord. So they cannot go beyond the pleadings, my lord. In the memo of appeal also, they did not make any such prayer, my lord. So, my lord, my humble submission before your lordship, this issue is fairly covered with this Rule 10. And so far as terminal charge is concerned, my lord, the information which we acquired from the RTI, that is also confirmed that the destination station is Bharat Petroleum Corporation Limited. And their circular also says that if the consignment delivered at the private siding, then terminal charges shall not be leviable. So this is an illegal collection, my lord. Very simple case, my lord. They are making such stand before this court. They did not take such stand like here, my lord, beyond the pleadings. They cannot go beyond the pleadings, my lord. This is my humble submission before your lordship. Lordship may peruse the circular. Their circular itself says that terminal charges shall not be leviable in case of consignment booked from private siding. And so far as my lord submission on with regard to section 64, that is forwarding note, there is no such record. There is no such, my lord, forwarding note in the record, my lord. And they did not make such stand in the written statement also, my lord. There is no such submission and any materials placed before the Railway Claims Tribunal, my lord. They have failed on their part to prove their case, my lord. Now they are making their stand beyond their pleadings of the case, my lord, which will not be acceptable, my lord, in the present case. This is my humble submission.
Lordship, reported my learned friends, Annexure 4, page 34. Just for my memorandum of appeal. That circular 29/10/2010. My learned friend has already mentioned point 2.
It's in page.
Page 34 of my appeal, memorandum. The terminal circular, suppressing of the earlier all the circular, this is the latest one where we have gone through. Lordship has got it, page 34, Annexure 4.
Lordship, the circular which I have given here is making
in record also. Same. Just I want to read one.
I am relying on para 2, my lord.
That same parameter, what my learned friend has relied, may I read your lordship? the terminal charges will be levied only on Indian Railways own terminals and sidings. It will not be leviable on terminals owned by customers, port, trust railways, and on port sidings. These charges will be collected at the time of issue of railway receipt itself, Your Lordship. These charges will be leviable on loading and unloading terminals independently and separately on the basis of chargeable weight at the time of issue of railway receipt. Figures of any subsequent weightment shall not be recovered for levy terminal charges. Now, repeatedly, RR means railway receipt. Railway receipt says that after receiving the forwarding report, I came to a conclusion, and that conclusion says the railway receipt is a primary document evidence of the consignment. On the basis of that railway receipt, we have done this. So far, RTI is concerned, that have mentioned by Justice Rumifikon judgment on page 72. I don't want to read paragraph 12. Paragraph 12. You asked me a question whether bus or in railway other siding. I said yes. But the question is that, Your Lordship, whether I have taken any levy charges beyond the railway's own sidings. That is a question. We have not taken. And so far the record says, Your Lordship, I again mention, Your Lordship, in my record, I have seen that page 298. It has been mentioned, assuming, Your Lordship, if your charges is beyond the jurisdiction from the railway terminal also, what is the calculation? My Lordship, that has been there, Your Lordship. And so far the point of amount is concerned, Your Lordship, again I say, it is a mention in my affidavit, in my petition memorandum appeal. I wrongly mentioned about the integrated management system, but it has been mentioned about the, Your Lordship, it is called in tripartite agreement, it has been mentioned as a terminal management system, page 49. There, everything is there. How you can deal, what you can do. Now, my Lordship, again I put a question myself, whether it is for one day. It is a continuous process. It is a continuous process. And my Lordship, my friend has mentioned about a forwarding report, it has not been there. It is there. I don't want to rely on that point. Only railway receipt. My whole crux is on the railway receipt. Nothing else. The Union of India, Minister of Railway can take any search which is not beyond the jurisdiction of railway? No. That's the point. And even the Eastern Railway, they have mentioned the bus is the Eastern Railway. Is the Eastern Railway. Assuming if the train has been derailment in the between the originating station and destination station, can the NFL is liable for that?
That for them it was from a private siding to another private siding.
Private?
Yes, the terminal is not applicable.
Lordship, that private siding, that Rongapani and the bus is under NFL siding.
Those are under railway station, but
railway
the
station
is from most probably
up to bus. They have the servicing station at some another station. We have not levied on that service, Lordship. My Lordship will go to the railway receipt. It will be very clear.
My Lord, may kindly peruse railway receipt. It's at page 1 to 50. Any railway receipt, my Lord. Page 1 to 50 of the LCR. LCR is there, my Lord. 1 to 50. Lordship, may peruse page 1.
LCR.
Railway receipts, my Lord. He is relying on railway receipt. So, railway receipt in this column, my Lord.
These are 154.
Page 1 to there are total 50 railway receipts, my Lord. Any railway receipt may kindly be perused.
Who actually prepared it? They made the presentation. All the presentations are the one is in the last page.
So,
Anyway, these are the receipts.
These are the receipts executed under Section 65 of the Railways Act 1989. As per this contention, my lord, railway receipt is the prima facie evidence of the weight. Now, my lord, in this railway receipt, there are two columns. In one column, it is mentioned that Messrs. Numaligarh Refinery, NRL, Rangapani. Got it? And just next to it, my lord, it is mentioned that Messrs. Bharat Petroleum Corporation, Bajbaj. It is mentioned here, madam. So Bharat Petroleum Corporation Limited and Bajbaj. This Bajbaj station is a serving station. But here, the consignee name is mentioned here, my lord. They very well know that this consignment is going to deliver at the siting of the Bharat Petroleum Corporation Limited. It is there, my lord. So now they cannot deny that this consignment was delivered at Bajbaj. Our contract is with them that the consignment will be booked from one siding to another siding. So as per the contract, my lord, as per the tripartite agreement, they ought to have been delivered this consignment to the siding of the Bharat Petroleum Corporation Limited, which they have done, my lord, in this case. And now they are saying that no, we have levied the terminal charges up to Bajbaj, and from Bajbaj to the siding of Bharat Petroleum, we have not levied any terminal charges. This stand is completely false, madam. It is their circular. They are saying that if the consignment booked from one private siding to another private siding, then the terminal charges will not be leviable. Now they cannot say that we have charged from Bajbaj, and from Bajbaj to Bharat Petroleum siding we have not levied any freight, my lord. So this submission cannot be entertained at this stage, my lord. This is the railway receipt, my lord. They are relying on this, and now the consignee name is very much clear, my lord. They know very well that this consignment was going to deliver at the siding of the Bharat Petroleum Corporation. And so far as tripartite agreement is concerned, my lord, this tripartite agreement may kindly be perused. It is also there, my lord, in the memorandum of appeal. They have annexed it. Lord, you may kindly come to page 48. 48 of the memorandum of appeal. And 49 is the clauses, my lord. Whereas, it stands for whereas, the railway transport goods from one railway station to another railway station. Consignor utilizes the service offered by railway for transportation of its oil and any other permissible commodity from one railway station to another railway station. Here, my lord, the booking station is Numaligarh Refinery, and the another station, that is destination station, is Bharat Petroleum. So there is an agreement between both the parties that they will book the consignment from one railway station. Here, the Numaligarh siding is the station, and to it another station. So as per this agreement, as per this clause, my lord, they did not deliver the consignment to Bajbaj. If their contention is correct that we have booked the consignment to Bajbaj, so why they have not delivered this consignment to Bajbaj? Why they have delivered this consignment to Bharat Petroleum? If they have delivered this consignment to Bajbaj, then we can say that okay, the terminal charge is correctly levied. But here the question is, my lord, they have delivered the entire consignment at the Bharat Petroleum siding, my lord. So they have not delivered this consignment in the railway siding, my lord. So this is the clause that they have mentioned here categorically. And my lord, so far as arbitration fee is concerned, my lord, page 57. Sorry, page 58, my lord. Clause 7.
Yes.
Clause 7 says the consignor shall be bound by the debits made by the bank for the transaction carried out as per this agreement. if there is any dispute concerning the amount debited to the bank account of the consignor, the matter shall be resolved in terms of clause 11.6 of the agreement. And now 11.6 says that, my lord, it is at page 57, clause 11.6. In the event of no amicable resolution and settlement, the same shall be referred to the sole arbitration of the railway gazetted officer appointed to be arbitrator by the general manager and a railway. The railway gazetted officer to be appointed as arbitrator, however, will not be one of those who had an opportunity to deal with the matters to which the contract relates, or who in the course of duties as railway servant has expressed views on all or any of the matters under dispute or difference subject to the provision of the Arbitration and Conciliation Act 1996. The award of the arbitration shall be final and binding on the parties to this contract. This clause 11.6 will be applicable only when, my lord, if there is any dispute concerning the amount debited to the bank account of the consignor. So, if there is any dispute with regard to the payment, then clause under 11.6 will be applicable, my lord. Otherwise, my lord, this arbitration clause will not be applicable in this case. This is with regard to the payment, my lord. If there is any dispute with regard to the payment of the consignor, then lordship arbitration clause will be applicable. So, my lord, here Eastern Railway does not have anything to deal with this case because we have made our payment at Maligaon. So, as per Rule 10, my lord, Honorable RCT Guwahati has the jurisdiction to entertain this claim application. And number of cases were dealt by the Honorable RCT in the same issue, that is for the refund of terminal charges, and which were again challenged before this Honorable Court. And the submission made with regard to MFA 100 that the Learned Counsel just now said, my lord, that judgment is not applicable in our case. For a moment, lordship may kindly see that judgment also. This judgment was raised by them in their memorandum of appeal at page 67, annexure 11. In this case, my lord, here the booking station is a private siding, so terminal charges was not levied by them. But, my lord, Changsari is a station owned by the railways, which lordship may come to para 13. Here it is mentioned that it is not disputed that Changsari terminal shed is owned by the railway. So here, my lord, the point is, since the Changsari station is a railway station, so they have collected terminal charges, and the Honorable Court also held that the railway have correctly levied the terminal charges. But this is not my case, my lord. My case is that both the stations are private siding, and which is also admitted by them in their RTI reply, my lord, and it is an admitted position. And now they are denying that no, it is not delivered in Bharat Petroleum, it is delivered up to Bajaj, so we have correctly levied. This is the wrong submission. This is my humble submission.
Only one point. Back up to page 25. Only one point. The affidavit filed by the Numoligor. Date of booking, invoice, railway receipt number, from to whom? It has been mentioned, Numoligor Rangapani to Bajaj. It has been there. Then, in the last point, page 26, that it is to be fact that all the above noted 50-10 loose petroleum products so and so booked from Rangapani, a station of NF Railway, for a destination Bajaj station of Eastern Railway. Both booking and destination station fall under the West Bengal. It is there in the paragraph. Their statement.
We are also not denying that.
26 years.
My submission is that it is delivered in
Lordship,
Bharat Petroleum, so terminal charges will not be
now,
levied.
your Lordship, their affidavit, they categorically mention. I am not saying anything, your Lordship. Their categorically, they mentioned what they said in page 25, that it is a fact for our railway disputes on account of compensation, claims, refund of freight. We are in the habit of persuading railway administration for settlement of refund, overcharges, claims, and avoiding involving in litigations with the railways. These are the internal agreement which have been mentioned in the affidavit. My only point, what my learned friend, I don't want to argue on this point. Two affidavit I have filed. Two affidavit filed by the additional affidavit by railway. If my point is not submissive or not being impressive, I will not say. But so far the point of concern of the Eastern Railway is concerned, Your Lordship. My only one point, Your Lordship. Railway receipt was issued by whom, Your Lordship? NF Railway or Eastern Railway? This consignment also says, Your Lordship, Eastern Railway. Railway receipt also Eastern Railway. Money which have been paid, it is an agreement, but it should be integrated, terminal management system goes to that account. And their affidavit also in the NF Railway by say, okay, Numoligo has said, it is under jurisdiction. That is a point, Your Lordship. And so far RTI is concerned, if you ask me a question, whether you have taken a food or not, I can say yes, I have taken food. That is a question. That legal profession cannot say anything. If you ask me a specific point of issue on any RTI, that cannot be given any answer. What is the question? What is the answer? We don't know. Yes, bus, up to bus I have taken. I have not taken any other slight exceptions. That's my simple point. I leave it to Your Lordship. What my learned friend has said, I have nothing to say. That is the point.
Lordship, there is a direction of this court, by order dated 12/3/2024, where Lordship, the parties were directed to submit a written argument. Lordship, requires, and I have prepared this written argument.
You have?
No, Lordship, my agreement on the basis of the affidavit, two affidavit. My department has beautifully mentioned all the points which have been issued during the time of argument. I leave it to apologies for that point. I give all my stand on the 2 point of affidavit which is given by the railway. That is clear. I am deeply obliged. One another matter, amicus matter is there, Your Lordship, my Lordship, court, item number 26. Is it?
No.
Obliged.
May I please, Your Lordship, a judgment and order dated page 14.
20 and 21 is connected. Yes, everything.
So judgment and order dated page 14. Lordship, may I read reason and decision? Page 16.
Page 50.
16. Huh? 16, page 16.
1/6. Yes.
Reason and decision. On perusal of the evidence, it is seen that there are two sets of witnesses. The prosecution has examined 12 witnesses in support of its case, and to prove alibi, the accused person have examined 3 defense witnesses. Para 8. According to complainant PW1 on 15/1/2009 at about 11 p.m. when he found that his daughter was not inside the house, he went out and heard her daughter crying inside the house of his neighbor. Anijul, since he was no relationship with the family of the accused person because of an earlier case. He requested the BDP personnel to recover his daughter from the residence of the accused person. Para 9. According to PW2 Hassan Ali, on the midnight of the date of occurrence, complainant Moghrab Ali went to his house and requested him to recover his daughter Mofida Begum from the residence of accused Anijul Haq. Accordingly, he consulted with other members of BDP and went to the residence of the accused person. Thereafter, BDP personnel Monnaf Ali and Kazimuddin went to the residence of Anijul Haq and recovered his daughter Mofida Khatun. On asking, she told him that at about 10 to 10:30 p.m., when he went out from her house, accused Anijul Haq forcibly took her to his house by gagging her mouth with a piece of cloth and raped her. Para 10. According to PW3, Mofida Khatun, victim girl on 15/1/2007, she was reading at night because of her coming matric examination. After completing her study, when she went out from her house to answer the call of nature, accused Anijul Haq gagging her mouth, dragging her to his house, and after removing her clothes, intercourse with her, and she could not shout because her mouth was gagged with a piece of cloth and her hands were also tied. When she began to cry, local people gathered in front of the house of the accused person, and then accused Anijul Haq compelled her to climb on a jute scaffolding. At first, the door was not open, and when the local BDP personnel entered into the house, she removed the knot from her hand and came, but along with BDP personnel. In the meantime, accused Anijul Haq fled from his house. On the following day, her father lodged an ejahat in the police station and she was medically examined. Her statement was also recorded in the court of White Exhibit 1. In her cross-examination, she has stated that while she was forcibly taken into the house of accused person but could not shout as her mouth was dragged. After removing her pajama and underwear, the accused person took her to a bed and intercourse with her against her will. She also stated that the accused person penetrated his male organ into her private part and the sperm